My lord, I am mentioning order 41 rule.
Mention next week. We have taken several matters yesterday. Please mention next week. Call on the list.
My lord, subject to your lordship's kind sanction.
Next week.
Your lordship.
No mentioning. Yes.
Number one is
Lordship.
Written notes.
Yes.
Yes.
Lord, I had cited Lord his judgment, but your lordship said that you marked the paragraphs and gave it. So it's indexed and
Thank you very much. Thank you very much.
Lordship, we have already filed.
Yes, you have. The written notes of arguments filed by the respondents today be kept on record. Full stop. Since the matter was since the hearing was concluded by a different bench, comma, let it be deemed that the matter was reserved for judgment. এটা ঠিক করে দিয়েছেন? এটা ঠিক করে তো? এটাই তো? লাস্ট অর্ডার শিটটা কোথায়? কি রয়েছে?
last order was on the 6th.
Yes. Acha, since oral arguments were concluded on August 6, 2026, full stop. Let it be deemed that the matter is reserved for judgment by the said bench. উপায় নেই, সুপ্রিম তুমি কবে বুঝবে যদি রিটেন নোটস থাকে তাহলে তখন রিটেন নোটস ওরাল আর্গুমেন্টস কমপ্লিট হয়ে যাবে, তাড়াতাড়ি করতে হবে, তুমি বসে এটাকে করে বসতে হবে, মানে খুব তাড়াতাড়ি বসে রিটেন নোটসের ব্যাপারটা মিটিয়ে ফেলছে। অ্যাডমিন কি আপনি যাবেন না আমি যাবেন? Yes.
Well, it's sorry, I'm slightly late for mentioning a lordship.
No mention.
Friday matter was supposed to come up.
Special messenger cost has not been deposited. We find from the office report dated August 6, 2026,
I didn't do.
that special messenger costs have not been deposited by the appellants as per the direction of the court. Full stop. The time for depositing special messenger costs is extended for a fortnight from date. Full stop. In default, comma, the matter be placed under the heading, placed in the list under the heading Lozima for final orders.
But I will appear for the respondent.
Yes.
Yeah, but the appellant, well, there was a defect.
For why is it appearing as to mention
There was a correction needed, my lord,
in the order?
No, in the decree, my lord, so therefore it was done in the court below.
Oh, acha.
That is during within the list.
Bring the explanation. It has been corrected.
Place it under the order 41 heading.
Well, since now we are satisfied that sufficient explanation for the delay in correcting the records have been furnished by the learned district judge Purbo Medinipur. Push up next para. Since the certified copy of the decree of the first appellate court has already been corrected, comma, let the matter be listed under the heading order 41 rule 11 on August 17, 2020, Monday. প্রথমটা তো পার্ট হয়, দেখুন দেখে বলে দিই। Since the matter was heard in part by a different bench, comma lists the matter before the said bench. Whenever we sit, we'll try to sit some days. There are several matters, part-heard matters, with justice matter. Should will appear on that.
Item number 667.
Indian matter, my lord, I am appearing on behalf of the respondent.
এটাও পার্ট-heard. Same order. It will appear before Justice Bhattacharya and I. The other than part-heard.
Number 8.
This matter I'm appearing for the appellant here, my lord. My lord, the appeal arises from an award which was passed in relation to our land acquisition proceedings. My lord, the dispute Thereafter, the matter, this was a 2000, year 2000 reference. From that award, my lord, it had traveled to the High Court, and thereafter it went to the Supreme Court. In 2018, my lord,
Can't hear you.
my lord, in 2018, my lord, by an order of the Supreme Court, the matter was, the order of the High Court was set aside, and it was remanded back with regard to only for the purpose of calculation of the computation under the new act, the 2013 act instead of the 1894 act. Well, this was the only quantum of issue. My lord, the matter has to be heard out before, my lord. My lord, I'm praying if the matter can be taken up after a fortnight, because, my lord, I'm led by Mr. Shagor Bandapate, who has done the matter extensively at all stages.
We'll request both of you, both the parties, formally to file a calculation as per your version.
My lord, my lord.
And we'll keep it after.
My lord, absolutely. The issue is with regard to the land and the compensation that
Competition under the 2013 Act.
my lord, 2013 act, along with the quantums, because there are several classification I am to get with regard to the bushes and the calculation in terms of the years, number of years of the bush, and the total proceeds.
So
From-
since
that we will do, my lord.
since we are very weak in mathematics, you have to do that.
My lord, we shall do that. My kindly grant
I
us
can speak for
14 days
myself,
time.
just as they may be very good in mathematics.
No.
For all
Not
that I
at
know that
Not at all.
you are better in mathematics, so do that for us and we'll
lord.
copy paste and do whatever.
It is always the client who is best at mathematics when it comes to commerce.
Absolutely, absolutely. They get more. Anyway, learned
Much appreciated.
counsel for the appellants submits that the limited scope of you are for
And for the appellant, my lord.
authority or
Right, my lord.
learned counsel appearing for, because there are several appeals, in some of which you are the.
Yes, my lord. There are cross
Oh no, sorry, right. Cross appeal by you, cross objection by you.
cross objection by me, my lord.
One appeal also by you.
Yes, my lord.
Very well. Learned counsel appearing for Terai Tea Company Limited, comma, the appellant in FA 77 of 2012, comma, submits that the matter went up to the Honorable Supreme Court and was remanded for the limited purpose of computation of compensation under different categories within the ambit of the ওই acquisition requisition যেটা আছে পুরো নামটা দেখিয়ে দিয়ে দেবেন 2013 Act 2013. Full of next para, learned the both parties are requested to file their learned counsel for both parties are requested to file their respective computations in that regard in consonance with the direction of the Honorable Supreme Court on the returnable date. Full stop, next para. The matter shall next be listed on. When should you keep it? Give us a date.
Kindly gives us 4 weeks time, and then any date, my lord, we shall be. My lord, 25th, if it's so.
Very well. On the matter be next listed on August 25, 2026 under the same heading.
স্টেট খাটবে না
Number 11.
একবার চোখে দেখে নিচ্ছে ঠিকঠাক আছে এগুলি কি বসে বসে সুপ্রিম কোর্ট যেখানে আপনি আছেন 18 থেকে নিচে পাঠিয়ে করতে কালেক্টরে পাঠিয়ে দিয়ে ওটা করে দেবো উপর থেকে তাই করা হাইকোর্ট এটা করে ভালো
Yes.
I'm the appellant.
Found that Mr. Chattopadhyay is still not recovered, and as per the
No, last chance was given to you. No further time. We'll hear the matter. Yes.
No, but the ballot can hear the matter, but there is malad after that malad this is caused by industrial estate matter malad
Pardon?
caused by industrial estate matter malad where malad there are certain proposals and counter proposals were given by the parties malad for to settle the dispute.
Who has handed over this? You?
No, malad.
You.
The key.
this is the instruction I have got from WBSL.
New managing director. We can't
No,
depend on the whims of the of your managing director. He has to comply with the order of the court. Otherwise, we hear it expertise. Your managing director has joined, so he requires some time. Why should you give him time? Ask him to leave the job then, if he can't do the function. If he can't act as a managing director, then let him lose the job. As the new managing director has joined recently, further reasonable time is required to apprise new managing director. How dare he? Anyway, yes.
Now, my lord, now as a proposal, they have given us pursuant to your lordship's direction, my lord, they has given us the valuation of the property and the plants and machineries that were there. Now, my lord, so far as the plants and machineries are concerned, we have given them a counter proposal. They have given a valuation of around 4 lakh something. We have requested them if they can allow us to take out the plants and machineries. They have
We'll send
accepted
it to
that.
mediation, Mr. Shur. We can't keep this pending indefinitely.
They have accepted that, my lord, subject to, my lord, your lordship's, because there is an order of
They've
injunction.
accepted nothing.
That is,
They
my
want
lord,
time for managing director.
that is, my lord, now they are saying it today, my lord, and we have also, and for the land and the structure, they have offered 41 lakhs. We have requested them to pay a little more, or else, my lord, we will accept that amount and we will want to take out the plants and machineries. Now, my lord, for that we require an order from this honorable court because there is an order of injunction.
What sort of order do you?
My lord, that we can take out the plants and machinery. If your lordship kindly takes the documents that, my lord, they have handed over. Sorry, my lord.
Yes.
My lord, this is the, if your lordship kindly takes, my lord, I have paginated that at page 15 of the document.
Hmm.
My lord, this is the valuation report that they have.
What was the initial dispute about?
My lord, this was an initial dispute. My lord, they have given us a land on lease for 99 years. My lord, we have taken the land. Now, after that, my lord, it is their allegation that we have not acted in terms of the agreement. Now, they have issued a notice for eviction under the West Bengal land
So
eviction.
you want to leave the land now
We want to leave the land, my lord,
and take back the machinery.
take back the machinery and the valuation part, my lord, that they have offered us 41 lakhs in that valuation statement.
Yes.
41 something. We have asked them, my lord, in the first page of the letter, my lord, we have asked them to pay 60 lakhs for that. That is under consideration. Probably what she is trying to say, my lord, the new managing director, I do not know, but so if your lordship kindly.
So the new managing director wrote a letter asking for time to Mr.
That is, my lord,
Chattopadhyay, who is
that is
who
between
is the
business.
counsel for WBSIDCL, upon getting which he has become ill. That is established.
My lord, I have issued a letter to the managing director requesting him, my lord, it starts from page 1.
An adjournment is sought on the ground of
Kindly take some-
illness of learned counsel for the respondent, illness of learned counsel for WBSIDCL. We noticed from our order dated August 4, 2026, that a similar adjournment was made and we had given a last chance to the WBSIDCL. Full stop. Furthermore, learned counsel who is appearing today on behalf of the WBSIDCL hands over a written instruction dated August 5, 2026, according to which further within reasonable time close is required to apprise the new managing director who has apparently been appointed, about the whole matter. Full stop. Next para. However, we are rather surprised at the instructions, since the court cannot wait indefinitely at the whims of the managing director, new or old, of the WBSIDCL to hear the matter. Full stop. Since we had given a last chance, we refuse to grant further adjournments on the flimsy pretext which has been made out by the WBSIDCL. So next para, at this juncture, learned counsel for the appellant hands over certain documents indicating that the matter arises out of an eviction notice given to the appellant, upon which the appellant is now agreeable to leave the premises, subject, of course, to adequate compensation being given to the appellant for the machinery and other heavy duty equipment which are installed at the subject property. Full stop. Next para, learned counsel submits that the issue now boils down to the quantum of such compensation, to arrive at a final decision regarding which further some more time is required. Full stop. Next para. Mr. Shur, then how soon can you
kindly give us liberty to file a joint compromise petition. If parties get consensus at item, we will file a joint
we are
compromise
putting it out
petition.
of the list to
Well, then kindly give that liberty so that because we require.
Actually, we are keeping it 2 weeks after then.
Much of this. And with a liberty, my lord, if required, my lord, we will file.
Full stop. Next para. Since learned counsel for the appellant further submits that the parties are otherwise ad idem, principally comma, we adjourn the matter for a further period of a fortnight. Full stop, the matter be listed next on August 25, 2026. Full stop, in the event a settlement is arrived at between the parties in the interregnum, comma, a joint compromise petition shall be filed by the parties on the next date. Full stop. However, comma, if no such settlement is arrived at on the quantum of compensation, comma, the parties are directed to file their respective valuations in that regard, comma, supported by cogent documents.
And my lord, direction for taking out the plants and machineries, my lord.
No, first the compensation has to be ascertained.
Much.
Otherwise, we wouldn't have any option
is
to. I
okay.
mean, how would you ascertain that?
Much.
But Mr. Shud, please, we are making it very clear on the next date. Unless you file a compromise petition,
My lord, we will
you have to
be
file your independent valuations with documents.
with much.
Item number 12.
Yes.
Lordship, item number 12, I'm on behalf of the respondent, Lordship.
Yes.
My lord, in this matter, the Supratim are appearing for the appellant, my lord. Due to traffic jam, he is coming, my lord. I am playing.
In the meantime, you
short
start. You start.
my lord,
No password. Second matter, especially if it's the fourth matter, no time. Sorry.
Not brief, my lord.
What is the matter about?
Lordship, the matter about is that, Lordship, due to 3 allegations, one teacher was suspended and thereafter show cause was issued. Thereafter, she was dismissed from service. Thereafter,
You are for the school.
Lordship, I'm grieving the crux of this matter. Lordship, thereafter, Lordship, she filed one writ petition and the writ petition was disposed of by His Lordship, Honorable Justice, Mr. Abhijit Gangobadhyay. And His Lordship, Honorable Justice, Mr. Abhijit Gangobadhyay opined that this dismissal order is liable to be set aside. And she should join in this school within 48 hours. Thereafter, Lordship, against this order, the school authority preferred an appeal before the Honorable Division Bench. From Honorable Division Bench, we won the matter. Thereafter, Lordship, against this order, the school authority preferred an SLP.
Not the school authority. You won. Then they must have preferred. You won the appeal before the division bench.
No, I own the writ petition. Thereafter, school authority preferred the match appeal.
The writ petitioner owns the writ petition and you won the writ petition. You won the appeal.
No. Writ petitioner, I am on behalf of the writ petitioner. Writ petitioner.
You are not on behalf of the school.
No.
That is the first question we asked you. You said yes.
You told that we are for the school.
I'm London.
Anyway, you are for the writ petitioner.
I am on behalf of the writ
You won
petitioner.
before Justice Gangobadhyay, lost before division bench, and then went up to the apex court.
No, I did not. The school authority lost before the division bench, and thereafter, school authority went to the Honorable Apex Court.
Then what happened? Interesting story, actually. The version is changing every time you are saying. Let us get it very clear. You are the writ petitioner.
Writ petitioner.
You filed the writ petition.
Writ petition.
Won the writ petition.
Lordship.
School preferred an appeal.
School preferred an appeal.
School won the appeal.
No. Against the
appeal was dismissed or allowed.
Allowed. Appeal was dismissed, Lordship.
So therefore, they lost before both forums.
Lordship.
And then they preferred an appeal before
appeal.
challenge before the Supreme Court.
Not SLP, before the Honorable Apex Court.
Yes.
SLP before the Honorable Apex Court.
What happened there?
And Honorable Apex Court also passed in favor, also passed an order in favor of the writ petitioner. Thereafter,
chapter ends there. Then
thereafter, Lordship, we preferred a contempt application before the Honorable Division Bench, and by strength of the contempt application, the first prayer of the writ petitioner was solved.
What prayer? First prayer means you are reinstated.
No, first prayer was the monetary benefit.
Dues were given.
Lordship. Thereafter, Lordship, in the Honorable Division Bench of the Honorable High Court, the order of the order passed by His Lordship Honorable Justice Mr. Abhijit Gangobadhyay was slightly modified. The order was that the order of dismissal cannot be passed. So against the order of dismissal or in spite of order of dismissal, any kind of other minor punishment may be given. Lordship, thereafter, again the proceeding was started against the writ petitioner. Then, instead of the dismissal, the removal order was passed. Then we preferred
Instead of dismissal, removal.
removal order was passed.
What is the difference?
Lordship, I am coming. One is with stigma, another is without stigma.
How could
Thereafter,
it be without stigma?
Lordship,
How could it be without stigma? There were allegations.
removal is without stigma, dismissal is
Removal on what ground? There has to be a ground for removal.
I am coming, Lordship.
Ground is the stigma, basically.
Lordship. Now I am coming. Then, Lordship, we prefer the second round writ petition. Second writ petition. And the second writ petition was disposed of in favor of the petitioner. That means in favor of my client. And His Lordship, Honorable
Quickly
Justice.
run through the second round. We won't have the patience till then. Quickly run through the second round. Yes.
Lordship.
2-1. Then
Lordship, and the second, His Lordship, Honorable Justice, Mr.
judge's name is immaterial. Single judge passed an order. Allowed.
in favor of the writ petitioner.
School moved appeal.
Against this order, again the school authority preferred an
Obviously, then what happened?
before this honorable division bench.
What happened there? This is that.
Honorable division bench, Lordship, one stay order has been passed.
Good. So what? This is that appeal.
This is that
We are
appeal.
hearing it finally. Now we are hearing it finally. Mr. Dhara has also come. So let us see what the school has to say. You have got the history. Now give the geography. Panting and all these things won't do, Mr. Dhara. You have to argue on this matter.
Well,
No time.
no, we have
Take
relied
Ponder,
few
take your
judge-
breath, no difficulty. Take your breath and then argue.
well, we have taken the point of maintainability of the writ petition since no public element is involved. This is an unaided school. So, my lord, as per the Supreme Court judgment, as also several judgments of our High Court says, my lord, the writ petition is not maintainable.
Mr.
my lord,
Dhara, in the last round of litigation,
My lord, we
you
did
tell
not
them
take
what-
this. We did not take this point. My lord, consent, my lord,
the
that
first round you
time-
submit to the
my lord,
jurisdiction.
my lord,
and then take the point.
that time, my lord, I tell your lordships. This, my lord, we have filed, my lord,
The matter went up to the Supreme Court.
yes,
Maintainability point was not held, not taken even.
yes.
So if it was deemed to be
First time,
maintainable.
the employee was dismissed. Then the Honorable Division Bench has held, considering the acknowledgement by the employee before the committee that yes, I will not do it again. But, only the Honorable Division Bench has held. Now you listen to the quantum of the punishment.
What was the nature of allegation?
My lord, nature of allegation, my lord, several things, but previously, my lord, she never took a class, and for the exams for class, I can't recollect, the class 4 or 5
Very good. Yes.
exams
Three
were not
allegations, Lordship.
taken
Three allegations.
by her.
May I say, Lordship, three allegations? Lordship,
Yes.
one thing is the lack of communication among the other teachers.
Second,
Lordship, the second is that, Lordship, the class test, not the final examination, class test was not taken within time. This is the second allegation. And third allegation is that my client, that means the writ petitioner respondent herein, asked the authority of the principal. These are the three allegations, Lordship.
ask means
Actually, principal called him that why you are filing these kind of cases against us. Then my client said that you do not have any authority to ask this kind of questions. These three allegations, Lordship.
let us continue. Yes. Thank you. Take it. Yes. No seat.
Difficulty is one of my brief.
Take his brief.
We have filed one
Oh, Mr. Mujumdar is also there.
compilation of judgments, my lord, kindly.
If your brief has his brief is
yes.
coming, your brief is not coming.
Yes. 15th August jump time.
This was your brief all along.
No. Mr. Tiwari, Mrs. Tiwari's brief.
Compilation টা দেওয়া আছে compilation
Can you please
Compilation
shift
টা
one?
দেওয়া
Mr. Ghosh can sit and he can have a seat. He's arguing the matter. Do you have a seat behind you? No. No, then please take it. Sorry. Yes.
পয়েন্টটা নেই যেহেতু we have submitted to the jurisdiction.
Mr. Mujumdar, what has been told to us by Mr. Mukherjee is that one round of litigation, first round of litigation, up to the Supreme Court, division was modified to the extent that accepted her apology or something, and then apparently modified it to that other penal action may be taken. It came back, removed, writ petition allowed, against that this appeal. Mr. Dhar indicated that the first ground is maintainability. We asked him a question that was in the last round of litigation, it went up to the Supreme Court. If question of maintainability was not raised, it was a deemed acknowledgement of the fact that it is maintainable.
No, I'm not, the judicial pronouncement probably of our court that says, holds that it is not maintainable.
Can you take this point now after the first round?
But after
you participated there.
After the last round, when the court directed that a separate order be passed, when it comes up before the court for the second round, in the continuation of the proceeding, I take this point.
Very well. Unaided school, that's fine. Not
private, unaided school, a private contract. Unapproved teachers. But please, I need not trouble your lordship. The Constitution bench judge, I mean the 11th bench judgment of the Honorable Supreme Court in 2002 has laid down as a proposition.
Beside that, we had required to be appraised. Yes.
Compilation আছে না?
Thank you. Yes.
Please come to the first one, which is at pages 1 to 21 of the compilation.
What is the citation?
It's 2022.
No, এটা না.
হ্যাঁ, করে দেওয়া রয়েছে।
This is the other side's compilation.
Yes.
Your compilation. As usual, without an index.
This compilation.
Without an index. Yes, Narayana School.
And please take note paragraphs 26 to and 28 of the report, which will appear at pages 13 to 14. No, I'm sorry. This will appear at page 20, running page 20.
So this is our High Court judgment. So you said 11 bench judge.
I'll also cite that. Not directly on that point, but I just take your lordship through these 4 judgments and take your lordship. Paragraph 26 in the instant case at running page 20.
Running page 20 is 105 in bold letters. Yes.
Running page 20, not paragraph 26 is at running page 20.
There's no paragraph 26. Something is quoted.
Oh, 26 of another judgment. This is not para 26 of this judgment. Within quotation, page 23. At page 23, 26 quoted judgment.
Quoted judgment. Yes.
23, 20. No, the court ends.
This judgment doesn't have any numbered paragraphs. So, where will you take page 20?
It begins with the words in the instant case. The paragraph begins with the words.
Let us come back to page
2022 SCC online Calcutta 457. The first judgment in the compilation.
Yes. Page 20 also does not.
So, it's not from SCC online. That is why.
Oh, yes. You have quoted SCC, but you have given the server copy. This is a server copy. You don't have the SCC copy.
Oh, I'm sorry.
It would be better if you got the SCC copy. These are not numbered paragraphs also. Nothing is telling.
In the instant case, paragraph 26.
You can find that out for us, Mr.
Kindly, only 1 minute.
Mr. Dhar.
In the instant case, just after paragraph 26.
Please find out that page for us, Mr. Dhar. Find করে দিতে হবে একটা ফাইন্ড করলে করে আমার দিয়ে দিলে ওনাকে ওটা খুলে দিই।
একটা করে জেরক্স করে দিতে হয়, একটা রেডি করে সব জেরক্স করলে তবে
Yes, that you will do in the meantime, and in the meantime you are following. Yes, Mr. Dhar, find it.
আরো পরে আরো পরে আরো পরে আরো পরে। না না আরো পরে পরে in case the dispute pertains to the action of the appellant, running page 35. In reducing the salary to the extent of 40% and the stoppage of salary from the month of July 2020. Admittedly, the respondent number 1 was appointed by the appellant initially for a probation period which was extended from time to time. There is no rule governing such service nor such appointment is required for the approval of the appropriate government. Similar is the case here.
No, she was not on probation.
No, she was not on probation, but
on
not,
the ground of probation.
first of all, it was a private contract. The service conditions not requiring approval of the government, and it's a contractual payment.
Right.
And therefore, in absence of any rules pertaining to such services framed by the appointment, it assumes a pure character of a private law, and therefore the writ jurisdiction cannot be invoked to enforce the private contract. Now coming to paragraph 28, but just skipping one paragraph. The paragraph, since it is not paragraph. We therefore do not find that the decision of the single bench in this regard can be sustained wherein it has been held that the appellant discharging the public duties or functions are amenable to the jurisdiction of the writ court, and the writ petition in this regard is maintainable. We have already held that the respondent number 1 has sought to enforce the rights emanating from the private law, even if the appellant, being the private unaided educational institution, is discharging the public duties or functions, but the writ petition is not maintainable in relation to a cause of action pleaded in the writ petition.
Yes. Yes, Mr. Majumdar.
Number the Supreme Court judgment, the being the next one, 2023 4 SCC 498. But I believe
Yes.
that if it is the SCC print,
Yes. Yes.
I hope it's the SCC print.
This is luckily the SCC one.
Yes, please come to paragraph 75 of
Yeah,
that
see.
report. Running page 87.
Yes.
And the court was summing up the final conclusions as under paragraph 75. An application under article 220, no, this was termination of service of a peon in a school, private school. An application under article 226 of the Constitution is maintainable against a person or a body discharging public duties or public functions. The public duty cast may be either statutory or otherwise, and where it is otherwise, the body or the person must be shown to owe that duty or obligation to the public involving the public law element. That was the first test. Similarly, for ascertaining the discharge of public function, it must be established that the body or the person was seeking to achieve the same for the collective benefit of the public or a section of it, and the authority to do so must be accepted by the public. Even if it be assumed that an educational institution is imparting public duty, The act complained of must have a direct nexus with the discharge of public duty. Pausing here for a moment, please recollect our court's judgment in the Honorable Single Bench. His Lordship held that causing an election of students in a school or a college is not a public duty. Therefore, it was not held to be maintainable. It is indisputably a public law action which confers a right upon the aggrieved to invoke the extraordinary writ jurisdiction under Article 226 for a prerogative writ. Individual wrongs or breach of mutual contracts without having any public element as its integral part cannot be rectified through a writ petition under Article 226. Wherever courts have intervened in their exercise of jurisdiction under Article 226, either the service conditions were regulated by the statutory provisions or the employer had the status of quote-unquote state within the expansive definition under Article 12, or it was found that the action complained of has public law element. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its action becoming amenable to judicial review by a constitutional court, its employees would not have the right to invoke the powers of the High Court conferred by Article 226 in respect of matter relating to service where they are not governed or controlled by the statutory provisions. Pausing here for a moment, CSC's employees. Not the burning example, not which we quite often give to the in respect of service matters. An educational institution may perform myriad functions touching various facets of public life and in the societal sphere, while such of those functions as would fall within the domain of quote-unquote public function or public duty be undisputedly open to challenge and scrutiny under Article 226 of the Constitution, the actions or decisions taken solely within the confines of an ordinary contract of service, having no statutory force or backing, cannot be recognized as being amenable to challenge under Article 226 of the Constitution. In the absence of the service conditions being controlled or governed by statutory provisions, the matter would remain in the realm of an ordinary contract of service. Even if it be perceived that imparting education by private unaided school is a public duty within the expanded expression of the term, an employee of a non-teaching staff engaged by the school for the purpose of its administration or internal management is only an agency created by it. It is immaterial whether A or B is employed by school to discharge that duty. In any case, the terms of employment of contract between a school and non-teaching staff cannot and should not be constituted to be an inseparable part of the obligation to impart education. This is particularly in respect to the disciplinary proceedings that may be initiated against a particular employee. It is only where the removal of an employee of a non-teaching staff is regulated by some statutory provisions, its violation by the employer in contravention of law may be interfered with by the court. But such interference will be on the ground of breach of law and not on the basis of interference in discharge of public duty. Not pausing here for a moment. Let's say a clerk in a private school. Not he has been terminated without complying with the provisions of retrenchment compensation being paid under the then Industrial Disputes Act, now under Industrial Relations Code. Will a writ petition be maintained? Because to that extent, there is a statutory provision which has not been complied with by a private body. Then the next paragraph. From the pleadings in the original writ petition, it is apparent that no element of any public law is agitated or otherwise made out. In other words, the action challenged has no public element and the writ of mandamus cannot be issued as the action was essentially of a private character. In view of the aforesaid discussion, we hold that the learned single judge of the High Court was justified in taking the view that the original writ application filed by respondent number 1 under Article 226 is not maintainable. The appeal court could be said to have committed an error in taking a contrary view. In view of the aforesaid, the appeal succeeds. রানিং পেজটা বল ঠিক আছে প্যারাটা বল পেজটা বল
Page 19.
Minute observation.
Oh no, I'm so question of percent. Judgment is 50%. None observation.
Yes, sir.
একটা থেকে জেরক্স করে নিল না কেন? কি বলবে এদের? না টার্ম স্টেট বা ওটা কোথায় আছে? The next minute the delay is because of that print and the photocopy of the reported decision.
Oh, the next one is also similar.
Yes,
Oh,
the question before us, the
but here there are paragraph numbers. You can, if you refer to the paragraph, what is
no,
your
the next paragraph, the next judgment is 2024 SCC Online Calcutta 2923.
what is your paragraph number?
But mine is 30,
Let us
20
see.
and then 30.
Let us see 20 first. Let us see whether it tallies, may tally also.
Well, I'll try. 20 হচ্ছে the question before us.
Is army welfare? 2024
তো আগে হবে না, পরে হবে না।
পরেরটা চলে গেছে।
Page 108, paragraph 20.
Quotations, we are not.
Down below that page, the paragraph begins with the words, the question before us is. Running page 108
What? Of this?
of the compilation, yes.
Achha.
The last
Yes.
two lines probably of that page begins with the words, the question before us.
Question before us.
The question before us is whether the read jurisdiction of High Court would be extended to the subjects relating to functions and orders of private institutions or not. Indubitably, as per scheme of Article 32 and 226 of the Constitution, the writ is entertainable only against the acts of state or statutory body of like nature. But please note the expression entertainable. So, prior to delving deep into the domain of discussion on the maintainability of writ of mandamus against private entities, it would be apt to consider whether private institution would come under the purview of state within the meaning of Article 12 of the Constitution of India, and to reproduce the interpretation of the phrase, the words, quote unquote, any person or authority used in Article 226 to see whether private entities would come under this phrase or not, and if yes, then to what extent. Then what I need not detain your lordship not on the deliberation on what art state is. Please come to not paragraph 29, not which could be at page. দেখো তো জয়তী মন্ডল বলে একটা আছে।
Page 140.
Yes, not page 111, running page 111, paragraph 29.
Yes.
In Jayanti Mondal versus State of West Bengal, reported at so and so, the fact of state control was considered and held as under. No single factor is decisive as to whether or not a body is state or other authority within the meaning of Article 12. Of course, if the administrative or financial control of the state over a body and its internal affairs is all pervasive, clearly the body would be amenable to the jurisdiction of the High Court. However, even an unaided institute enjoying complete autonomy and free from state interference as regards its internal administration may be amenable to the writ jurisdiction if the institute discharges functions of a public nature. It is irrelevant whether or not such public function is being performed pursuant to any statutory mandate. If a body operates in the public field touching the lives of public at large, its acts and omission should be amenable to judicial review on the usual grounds of arbitrariness, unreasonableness, breach of natural justice, etc. A similar observation was made in Santa Kanungo versus so and so, wherein the learned judge also dealt with the connotation of words public duty as distinguished Ramesh Aluwalia by stating that imparting education to children is covered under Article 21A. coordinate bench of this court has also decided this issue in Mat Narayana School. But that particular paragraphs are quoted.
Yes.
Then please come to paragraph 32. In the case of Ramakrishna Mission versus Kago Kunia, learned judge held that Ramakrishna Mission is state within the meaning of Article 12. It was challenged before the learned division bench, who observed that while Ramakrishna Mission may not be state within the meaning of Article 12 in the strict sense of the term, nonetheless its hospital at Itanagar performs a public duty and in consequence would be amenable to the writ jurisdiction under Article 226 of the Constitution. Ultimately, the order passed by division bench was challenged before the Supreme Court, who drawn inferences or conclusion that, quote unquote, contracts of a purely private nature would not be subject to writ jurisdiction merely by reason of the fact that they are structured by statutory provisions, except where the contract of service is governed or regulated by a statutory provision. So neither the Ramakrishna Mission nor the hospital would be an authority within the meaning of Article 226 of the Constitution. Accordingly, the view of the learned division bench of the High Court that the appellants are amenable to the writ jurisdiction under Article 226 as an authority within the meaning of the article was not based on correct position of law. Its ratio was verified, tested, and applied by Supreme Court in subsequent cases like St. Mary's, not the immediately before citation, wherein it was held that every public function or public duty would not make a writ petition to be maintainable against an authority or a person referred under Article 226 of the Constitution, unless the functions are such which are akin to the functions of the state or are sovereign in nature. A full bench of the High Court of Allahabad in Uttam Chand so and so. But I skip over the Allahabad High Court judgment. Lordships may straightway come to note the paragraph beginning with the words. We have heard both sides in full. But it's paragraph 37. If it's at 115, as Mr. Dhar prompts.
Yes.
We have heard both sides in full.
Yes.
Considered the legal propositions and given anxious thought to questions posed before us to decide. In the light of the guidelines and principles as laid down by the Honorable Supreme Court, we considered the existing facts and circumstances of this case. Indisputably, the appellant was appointed with a letter dated so and so, represented at so and so. But he was assisted as assistant professor in electrical department at Calcutta Institute of Technology. Your Lordship will be pleased to find from the italics, which quotes the appointment letter. Now, please come to paragraph 43, which would be page
118.
118. Paragraph 42 first. In any event, we find that the law is now well settled that private institution would be amenable to the writ jurisdiction of High Court only when it is performing public function or the order bears public element therein. Actually, the principles laid down by Supreme Court are clear on the point that the writ of mandamus can be issued to any person or authority, including private entities and persons, if the said person or entity is performing a public duty or owing a positive obligation. It is immaterial if the public duty is conferred by any statute or regulation while performing a public duty by a private body or any other body. If any individual rights are infringed, then the court shall consider the writ of mandamus and restore that right. Barring few exceptions, the Honorable Supreme Court has expanded the vistas of the writ of mandamus by observing that this writ should not be considered in the watertight arrangement, but it should be widened to the extent necessary for providing complete justice by imparting new meanings to the expression any person and authority used in Article 226. In view of the above discussion, we may conclude that High Court may issue prerogative writ against private unaided institute or private body only when it is discharging public functions and duties akin to the sovereign functions and discharged by the state, but writ petition for enforcement of private contract of service is not maintainable. Not something like the old section 14(1)(d) of the Specific Relief Act. It is also settled position of law that when a right is created by a statute, please not take note of the expression right created by statute, not under statute, which itself prescribe the remedy or procedure. For enforcing the right or liability, resort must be had to that particular remedy before invoking the remedy under Article 226. In other words, we can say that a writ petition under 226 is maintainable only against those functions of private unaided technical institution or private entities which assumed to be performed by state, affecting the interest of people or have public element therein or discharging any public functions and duties akin to the sovereign functions as discharged by the state. The other functions of the private institutions which do not affect interest of public would not come under the realm of writ jurisdiction of the High Court. It means that no writ petition for enforcement of private contract of service, that is appointment, discharge, and other service conditions of teaching and non-teaching staff, and against a right created by a statute which itself prescribed the remedy or procedure for enforcing the right or liability would be maintainable in the High Court, because resort must be had to that particular statutory remedy. Therefore, a service dispute in the private realm involving a private educational institution and its employees cannot be adjudicated by a High Court in its jurisdiction. Now, this was considering St. Mary's as delivered by the Honorable Supreme Court. But I need not multiply, but not just for reference. There is a fourth judgment on the point, which is paragraph 19 টা দেখো আর্মি ওয়েলফেয়ারের
পেজ গুলো
হুম।
পেজ 43 একটু দেখাবো ঠিক আছে 45 তো
না
দেখাবেন
না,
ঠিক আছে
please come to note also. I am slightly mistaken. Please come to note paragraph 44 also of the report. Consequently, we are of the view, not of the same report. That's running page 11.
Yes, consequently.
8. Consequently, we are of the view that all decisions of a body performing public duty are not amenable to writ jurisdiction of a High Court, but only those decisions will be reviewed under writ jurisdiction which have public element therein. A service dispute in terms of the private contracts in a private educational institution and other disputes of its employees arising out of a contractual relationship would not be adjudicated by High Court in a writ petition filed under 226. Accordingly, we are of the view that no writ of mandamus can be issued to private respondents against the impugned orders, as is not affecting any public right. Secondly, it is also imperative that the writ of mandamus can only be issued if there is unavailability of equally convenient remedy. In present case, appellant did not exhaust the appropriate remedy. Moreover, the appellant challenged orders of the respondent number 7, which affected his public personal interest. He did not utter anything about how his order affect the respondent number 6 in discharging his duties towards student. Affiliations of West Bengal Technical University and AICT and receiving of grant in aid, etc., not relevant consideration in this matter. Therefore, the court went on to hold that the writ petition was not maintainable. Now, the last judgment, but paragraph 19, if your lordship will kindly look at, which is 142, running page 142. That's the error. That's the error.
Yes.
Now, similar questions arose regarding service conditions. Thus, the error is in para 27 when the learned single judge says that since the school imparts education, the public element should be kept in mind. Undoubtedly, any institution imparting education discharges public duty and therefore public element may be involved. However, the learned single judge overlooked the fact that the dispute between the school and the teachers and also the non-teaching staff is relating to their service conditions. In such circumstances, public element will not come into play. Now, straightway please come to paragraph 38 of that reported judgment, which is at running page 167.
Yes. St. Mary's.
Now, reliance on placed on St. Mary's and how St. Mary's was considered by the coordinate bench. Now, please come to 40, 41, and 42. Not 40, I need not reiterate because it is only quoting. 41 and 42.
Forty-one is also full of quotation.
Yes, but 75 is quoted. I need not detain your lordship, but ultimately paragraph 50 is the conclusion drawn. Please come to paragraph 50. We have discussed in detail in preceding paragraphs that even if the function being performed by a private educational institution in imparting education may be considered as a public function, the relationship between the administration of such an institution and its employees remains a contractual one, falling within the ambit of private law. Now, not the 11 judge bench of the Honorable Supreme Court, which decided the point a long time back. Please come to page 546.
Yes.
Paragraph 60. Education is taught at different levels from primary to professional. It is therefore obvious that government regulations for all levels or types of educational institutions cannot be identical. So also, the extent of control or regulation could be greater vis-a-vis aided institutions. In the case of unaided private schools, maximum autonomy has to be with the management with regard to administration, including the right of appointment, disciplinary powers, admission of students, and the fees to be charged. At the school level, it is not possible to grant admissions on the basis of merit. It is no secret that the examination results at all levels of unaided private schools, notwithstanding the stringent regulations of the governmental authorities, are far superior to the results of the government-maintained schools. There is no compulsion on students to attend private schools. The rush for admission is occasioned by the standards maintained in such schools and recognition of the fact that state-run schools do not provide the same standards of education. The state says that it has no funds to establish institutions at the same level of excellence as private schools, but by curtailing the income of such private schools, it disables those schools from affording the best facilities because of lack of funds. Now, this is apropos not the question as to whether the private schools is discharging such functions which are akin to sovereign functions. If this lowering of standards from excellence to a level of mediocrity is to be avoided, the state has to provide the difference, which therefore brings us back in a vicious circle to the original problem, which is the lack of state funds. The solution would appear to lie in the states not using their scanty resources to prop up institutions that are able to otherwise maintain themselves out of the fees charged, but in improving the facilities and infrastructure of state-run schools and in subsidizing the fees payable by the students there. It is in the interest of the general public that more good quality schools are established. Autonomy and non-regulation of the school administration in the right of appointment, admission of the students, and the fee to be charged will ensure that more such institutions are established. The fear that if a private school is allowed to charge fees commensurate with the fees affordable, the degrees would be.
Yes, Mr.
Now, this is on fee charging. Now, paragraph 62. There is a need for private enterprise in non-professional college education as well. At present, insufficient number of undergraduate colleges. Not I skip over that undergraduate college because this may not be necessary for our purpose. It was submitted that for maintaining the excellence of education, it was important that the teaching faculty and the members of the staff of any educational institution perform their duties in the manner in which it is required to be done, according to the rules or instructions. There have been cases of misconduct having been committed by the teachers and other members of the staff. The grievance of the institution is that whenever disciplinary action is sought to be taken in relation to such misconduct, the rules that are normally framed by the government or the university are clearly loaded against the management. It was submitted that in some cases, the initiation of the disciplinary proceeding, while in other cases, subsequent permission is required before the imposition of penalties in the case of the proven misconduct. Please recollect those Rule 28 of the management rules, not Rule 27 and 28, when the West Bengal board schools not required to take approval of the board, I mean the government, at 2 stages, before initiating and after initiation. While emphasizing the need for an independent authority to adjudicate upon the grievance of the employee or the management in the event of some punishment being imposed, it was submitted that there should be no role for the government or the university to play in relation to the imposition of any penalty on the employee. An educational institution is established only for the purpose of imparting education to the students In such an institution, it is necessary for all to maintain discipline and abide by the rules and regulations that have been lawfully framed. The teachers are like foster parents who are required to look after, cultivate and guide the students in their pursuit of education. The teachers and the institution exist for the students and not vice versa. Once this principle is kept in mind, it must follow that it becomes imperative for the teaching and other staff of an educational institution to perform their duties properly and for the benefit of the students. Where allegations of misconduct are made, it is imperative that a disciplinary inquiry is conducted and that a decision is taken. In the case of a private institution, the relationship between the management and the employees is contractual in nature. A teacher, if the contract so provides, can be proceeded against and appropriate disciplinary action can be taken if the misconduct of the teacher is proved. Considering the nature of the duties and keeping the principle of natural justice in mind, for the purposes of establishing misconduct and taking action thereon, it is imperative that a fair domestic inquiry is conducted. It is only on the basis of the result of the disciplinary inquiry that the management will be entitled to take appropriate action. We see no reason why the management of a private unaided educational institution should seek the consent or approval of any governmental authority before taking any such action. In the ordinary relationship of master and servant, governed by the terms of a contract of employment, anyone who is guilty of breach of the terms can be proceeded against and the appropriate relief can be sought. Normally, the aggrieved party would approach a court of law and seek redress. In the case of educational institutions, however, we are of the opinion that requiring a teacher or a member of the staff to go to a civil court for the purpose of seeking redress is not in the interest of general education. Disputes between the management and the staff of educational institutions must be decided speedily and without the excessive incurring of costs. It would therefore be appropriate that, and not this Mr. Vasu will have to answer the other part without incurring costs.
He has set up at the panchayat level. Educational tribunal. Oh, he's not there. Let him come, then we'll see.
That an educational tribunal be set up in each district in a state to enable the aggrieved teacher to file an appeal unless there already exists such an educational tribunal in a state. The object being that the teacher should not suffer through the substantial costs that arise because of the location of the tribunal.
Mujumdar, till tribunal is not set up, let us skip this portion.
No, but that important line was
very important. Yes,
that it
We
was a
understand
private
it,
contract.
but that we have marked.
That civil court. Normally, civil court, to do away with this, tribunal be constituted. But as a proposition of law,
The tribunal is not constituted, then the civil court is not the appropriate forum.
no, it says so. Please come to the previous page.
Yes.
In case of just
Private
against
institution.
President G.
Yes.
In the case of a private institution, the relationship between the management and the employees is contractual in nature.
That's the only sentence we have marked in this part.
Yes. Not please read this apropos the other findings in the coordinate bench judgments.
Yes.
Now,
Okay.
please turn over to Placitum B on the next page.
Yes.
Disputes between the management and the staff of educational institutions must be decided speedily and without just the
This is the
I'm sorry.
Yes.
In the ordinary relationship of master and servant, governed by the terms of a contract of employment, anyone who is guilty of breach of the terms, could be the school, could be the teacher, can be proceeded against and appropriate relief can be sought. Normally, the aggrieved party would approach a court of law and seek redress. Stop. In the case of educational institutions, however, we are of the opinion that requiring a teacher or a member of the staff to go to a civil court for the purpose of seeking redress. So, the normal redress is approaching a civil court. To that extent, I say
Understood.
that law, the tribunal has not been
Not be efficacious, that's why it should be set up. But till that is set up, you say
civil court is the
that is recognized.
Yes.
All right.
I'm not having taken the point in the first round. Am I stopped from taking the question of maintainability? Now I'm not
merely a question of estoppel. Yes, please argue and then at least issue estoppel.
Not in the first round. The court has remanded the matter to the school. Take a decision except dismissal.
Not remanded, modified, leaving it open for you to do whatever. That's a subsequent cause of action.
But the
matter is not remanded.
No, the clear observation is don't dismiss.
Yes, dismiss not the writ petition, but
the employee.
Yes. So
Don't-
therefore, you went up to the Supreme Court, and up to the Honorable Supreme Court, you not only tacitly, you actively participated and waived this right of taking out a challenge.
No,
And it's a tacit recognition by both the division bench and the Supreme Court also that the writ petition was maintainable by passing orders on merit on the writ petition.
yes, because the courts were not invited to decide on the point.
Can you do it at any point of time after having a round of litigation up to the Supreme Court?
Now, I'm not.
At any point of time, you come up and say this is
Not-
not maintainable.
not-
Now, because this goes against me, now this is not maintainable.
But for the time being, let us, if I may argue in this way, a point of law is decided amidst these proceedings.
That is the second question, Mr. Majumdar, whether this is a pure question of law, because it's a factual consideration. Whether
No, he says that it's an unaided private institution.
we have to adjudicate to public function discharge, the scope of the private
So
contractor.
the judicially propounded the law is in a private contract, there is no public law element involved. Even if
It's a public,
even if
public functions
the
discharge.
school discharges public
Yes.
duties, not a student, it may be discharging public duties, having and the action may be having public law element,
not during the contract.
but not in the employment relationship. That's what the law is.
Wouldn't it be absurd if and the previous round of litigation went up to the Supreme Court, nobody took the point, and Supreme Court tacitly accepted the proposition that a writ petition is maintainable, because up to not only it was not taken by you, but it's a tacit recognition of the fact that a writ petition is maintainable because orders are reliefs are given on merits on the writ petition.
Not,
So that is also one of the aspects we are thinking.
not
Now,
if as we try to learn, issue is crossing of swords.
yes,
The swords did not cross at that stage.
and it's not a
I did not raise that point.
true, but this is not an inherent lack of jurisdiction. Also,
No, it's not inherent. Not,
intentability,
That's-
entertainability, not maintainability.
yes, no, that's why
26 is
that's why I laid stress on the word entertain.
yes, you did.
But there is a
In all fairness, you did.
there is a 2025 judgment of the Honorable Supreme Court now, which makes a distinction between entertainability and maintainability.
Discretion of the court 226 that has been exercised up to a particular extent in this particular matter between the same parties. Now, whether you can take this point, whether it would be against judicial decorum to permit you to take this point,
Yes, now I'm not.
because if we permit you to take this point, you have a good ground. So that's also what we are balancing.
Now, I have not taken a point at an earlier stage. The court has remanded.
Not remanded. That
Very well. You are at liberty to take a step.
yes,
You are at the school is at liberty to take a step.
it's a different cause of action, new cause of action.
New cause of
That
action.
matter is disposed of. This is set aside, but this does not preclude you from taking lesser steps or modified, whatever.
Not I take a step which is challenged in a writ petition.
Hmm.
But in continuation of that writ proceeding,
Hmm.
or in course of this writ proceeding, I am not saying writ petition, writ proceeding, I take this point that this is not a fit case to be entertained by reason of judicial pronouncement.
Hmm.
It's a judicially recognized principle now.
Yes.
Even in respect of teachers of a private school, it's a private contract which is not enforceable through a writ of mandamus. The court does not say that he is remediless. But the normal remedy had been pointed out in 2002 itself. Now, what is the exceptional remedy which warrants this writ petition to be entertained in this court?
So what is your answer to not taking this point previously? What is the precise answer?
Probably the principle of estoppel or res judicata may not apply because I am taking this point in the fresh writ petition which emanates from a new cause of action.
If you say res judicata, then it's constructive res judicata.
No, it's not the same proceeding. A fresh order has been passed, which is being challenged.
All right.
It's not part of the same proceeding or otherwise.
But constructive res judicata is applicable to different proceedings also.
Different proceedings also, but not when he challenges this subsequent order before this court. I say that now this is the law and I am taking this point. You can't approach this court, you have remedy elsewhere.
All right. All right.
Not when the court says that in general it says in a private contract, a breach whereof enables a party to approach a civil court. So the remedy is identified. The forum is identified. And all these subsequent judgments up to 2024 in clear exposition holds that this is not the remedy. 2023 doubt was with regard to non-teaching staff. This has been explained in the 2024 judgment.
Very good. So this is on maintainability.
Now on merit, there are disputed questions of fact, whether she had applied for leave or not, to what extent natural justice was required to be complied with. These are all disputed questions.
Address that also. If we hold against you on maintainability, then you have to argue on the other points also.
Maybe.
So what you want to say something?
No, just check no, but I said how much time he will take.
He'll prepare himself during arguments, so he'll take time, some time, like you will do on the merits.
It's very difficult to match with his electricity.
কি চিঠি বললো? Please come to page 51.
Yes.
Of the stay application. It has been brought to the notice of school authorities that there is serious lack of coordination among the Bengali subject teachers of class 1 section C with the fellow counterparts in sections A, B and D. In spite of specific instruction from primary coordinators, consultation with other subject counterparts was not done in the current academic session. As a result, the syllabus of Bengali in class 1C progressed in a very slack manner and a certain chapter was omitted from the syllabus. The above action from your end has resulted in redrafting of Bengali question paper for unit test and annual examinations and rescheduling of dates of unit tests for class 1. You are to justify your action causing inconvenience of the students of the above classes by a written reply within 3 days from the date of receipt of this letter. So, an employee is put on notice that this is the lack of diligence or the misconduct committed by him or her.
This is the initial instance or after the first round?
This is 2012, the first instance.
First one, yes.
Then please see page 53.
Yes.
No, I'm sorry, page 52, not the reply.
And the cause of action remains the same
Same,
because
same.
liberty was given to you to
Same,
take.
same.
Right.
Chain of facts is same.
Right.
With reference to your letter noted above, I would request you to go through the under mentioned facts with some consideration. There was complete coordination among the Bengali subject teachers of class 1. Consultation with the other subject counterparts was done in all academic sessions, including the current one. Syllabus of Bengali in class 1C progressed well and was finished long before the annual examination. Not a single chapter had been omitted from the syllabus. The log books and Bengali exercise books of class 1C will provide ample proof. The Bengali question paper had not been redrafted. Only a question was added, that too much before the question paper was sent for printing. There was a rescheduling of the date of a particular unit test from 12th December to 19th December as per your instruction, as the Rhapsody 2011 took place on 9th and 10th of December 2011. There had been no slackening of course from my end. Rather, I had taken enough time to drill the subject matter well into the class, taking everyone in my stride. Now, I'm not the second instance at page 53 of 2013. The undersigned has been notified about a serious dereliction of duty on your part, details of which is enumerated below. On 11th February 2013, a note was received in the school diary by Miss Alkarani, class teacher 1C, written by the mother of Miss Anushmita Bhattacharya, Rule 4, copy in attached. The said note contained that although the Bengali recitation test was slated to be taken on 30th January 2013, her daughter was not taken the test till 11th of February. On the same day, it was brought to the notice of the Vice Principal, Miss S. Das. The Vice Principal summoned you and the TR primary, Miss Sonali Das, in her room to explain the matter. You opined that the said child was not good in studies and could not recite even a line of the poem when asked. Therefore, you decided to give her a second chance to improve the performance. The said people had stated before Miss So-and-so that neither a test was taken nor a second chance was given. On further investigation, a marked difference was found between your and Anushmita's statement. On being asked to clarify the matter before the Vice Principal, TR primary and the class teacher 1C today, that is 13th February 2013, you admitted that on the previous day, you had offered such an opinion about the student as you had failed to recollect the pupil's identity and had missed taking her test as you usually do not, and did not in this case follow a sequential order of roll numbers, but followed a random order while taking the test. You also admitted that even 3 classes after 31st January were not enough to complete taking the Bengali oral test of class 1C. You also expressed the opinion that the above lacuna was not your fault. In the light of the above incident, you were directed to explain in writing to the undersigned, justifying your position as to why an action will not be taken against you by the school authorities for the above incident. So, one is put on notice as to what the nature of allegations is against her. Then, please see the response at page 55. No, 55 to straight away.
Only, sorry for the interruption. May I take back the compilation in order to
No. No. Yes, Mr. Mudra, please continue. Which compilation will take back? That was relied on by the previous bench and will take back.
No, I will stop. I will resubmit.
After manipulating, no.
No, not manipulating.
Why do you want to take it back?
To mark the pay.
It's too late in the day. It goes for that. Whatever you have done, it's there. Yes.
At page 54 is a reply.
Which compilation?
The judgment compilation.
The slipshod one.
The slipshod one.
Without an index. You want to put in an index?
No, I'm just not. I will rearrange it. Only just.
Anyway. Yes, Mr. Sorry, sir.
Yes, page 54.
54, yes.
Please take note the last 3 or 4 lines.
Yes.
ক্রমিক সংখ্যা 8
admits the fault.
Yes. অনিচ্ছাকৃত এই ভুলের জন্য আমি দুঃখিত। অনুস্মিতা ভট্টাচার্যের মুখটি মনে করতে না পেরে 11/2/2013 তারিখে আমি যে মন্তব্যটি করেছি তার জন্য আমি হার্দিকভাবে দুঃখিত। Then not suddenly starts challenging.
This is regarding something else, Mr. Onmita Bhattacharya is also there.
Yes.
Right. Fair.
Then what we say that you are directed to explain in writing the reason for questioning the authority of the undersigned regarding allotment of invigilation duty in examination held on 10th February 2013 and accusing that you have not been allotted the duty deliberately by the undersigned. Also justify your attitude shown to the academic administrator which is in contravention to the employee code of conduct of the school. The letter has been issued in accordance with the decision of the EC meeting dated 12th of February 2013. Then Lord, he was asked to be present at the hearing. Please see page 30. There was a limited inquiry conducted. Page 30.
P0. Oh, it's the pleadings.
Yes, part of the pleadings.
Yes. Which para?
The first line on that page. On 11th July 2013, the petitioner appeared before the authority concerned of the school. It was the most astonishing fact that on that day, the level of the mental torture was increasing time to time upon the petitioner. On that day, by using some coercion and undue influence, the signature of the petitioner was taken by the authority on some blank papers. Then this was followed by a dismissal order with a right to prefer an appeal under Regulation 24A of the Code of Regulations.
Which culminated in the previous page.
Yes, which culminated in the previous page 101, the disposal by the Honorable Division Bench, page 101. না ওটা তো করেনি।
Yes.
Please come to 101. There's a division bench order. Your lordships have probably considered this in the meantime. Lordships may straightway come to 103.
Right.
The penultimate paragraph on that page, beginning with the words on the materials on records. We are of the firm opinion that the order of dismissal could not have been passed. We have perused the materials on record and we are satisfied that the order of dismissal was arbitrary and unjustified. We are of the view that a person who has admitted her laches for not being able to take recitation test of a student and not of the entire class could not have been punished with dismissal. We think this is not a major misconduct which would attract dismissal. So, one thing is very clear. The court returns a finding that she had admitted her laches. Proportionality of the punishment was only considered.
That was probably.
The disciplinary authority is accordingly directed to impartially consider the matter and decide on the question of quantum of punishment and pass a reasoned order.
Yes.
So that all things as regards violation of natural justice now goes to the backstage. It's only with regard to the confined to the quantum of punishment.
Yes.
and give an opportunity of hearing to the petitioner within a period of 3 weeks from the date of communication of this order, the period of termination would be treated as a period of suspension, and the appellant would be entitled to receive subsistence allowance for the aforesaid period in accordance with the rules. The judgment of the learned single judge stands modified to the aforesaid extent. However, this observation is prima facie and shall not influence the disciplinary authority in arriving at his own conclusion. I am not considering the nature of correspondence and not the relationship that had to certain extent soured between the petitioner and the school. Not we decided that this is not a fit case where one should be retained in employment.
Although we cannot subjectively, I mean, we cannot, it's a subjective assessment by you, and the employer has a wide discretion. But Mr. Mujumdar, what is our fault at the end of the day? I mean, just we are asking you to satisfy our conscience also on merits. That she suppose forgot to take the test of a particular student. Wrong on her part. She did not initially admit. That also you have noticed. After being called out,
that was a different issue.
Oh,
that was setting question papers.
No, but the same test not taken. That was a
That was a different. There were 3 instances.
Right.
2012 and 2013 too.
Test not being taken. The setting up of the paper. One chapter was probably omitted. That's why entire thing had to be restructured. Second is not taking the test. Third is insubordination in a sense. So she admitted which one? Third
one. No, third one is that not taking that recitation test.
No, challenging the authority was one of them.
That was also one of the grounds. Later on, she takes a different turn.
So she admits not taking the recitation test.
Yes.
No other admission.
No other admission.
So not taking a recitation test.
Number 2, what? Not there is a
that entail a removal.
No, there is a difference between dismissal and removal. Not as your lordship.
By challenging your authority.
No,
it's also writ large over your notices.
Of course, not at the end of the day.
No, employer has
a relationship.
But master servant concept has undergone a sea change. Nobody is a master, nobody is a servant.
No, that's not
so,
what.
Employer-employee, yes. There has to be some proportionality.
There are judgments.
I don't like your face, Mr. Mujumdar. I don't like the way you argue or dismiss your
Yes. That's also possible.
We do that.
Yes. No, I don't say that in court.
That's not proper.
I would held up in contempt.
No, that should be set aside in appeal. If you do that, definitely. We agree to that also.
The master servant concept is gone. Employer-employee relationship is there, but not still.
You took it in your head that I will remove this person, and you removed her. I mean, removal for not taking a recitation test.
Not every action has an element of predetermination.
Equal and opposite reaction.
But an element of predetermination. Every action.
True.
But if I may be allowed to quote from Justice Krishna Iyer, he said that we decide and then give reasons.
Yes.
So that is an element of predetermination in every action, be it judicial, be it administrative, be it not the other.
But there is something to the pre also.
Then comes the question of rationality. Rationality. Not to what extent the court, in the given facts and circumstances, I feel that what is paramount is relationship with the colleagues, number 1, how one arranges the classes, how one takes the tests, and how please visualize this from another angle.
Relationship with colleagues.
They said that she had not coordinated with us.
Supervisor. She's a teacher.
Yes, of course. She has not.
They have a very bad sour relationship with all her.
She has not coordinated in aligning the syllabus,
which she has denied categorically.
She has denied, might have.
And there is.
But she also went to the extent of denying that recitation test. And please visualize the situation when the student had to be called.
Recitation test.
When the student had to be called to verify the situation, is it desirable?
Not desirable.
Not desirable. So what is not desirable? Should it be allowed to retain? Here is a student who comes up before a teacher.
Although Chanakya Niti is now in vogue, Mr. Mujumdar.
Yes, of course.
But this is Chanakya Niti in the sense that you remove her. Just remove her because she irked you.
No. It's not
taking
that.
A recitation test. Fine.
The student comes up with her guardian and then a different version turns out, which she admits later on.
Yes.
Please visualize this from the angle of a student and guardian also.
Her punishment would be her ignominy when she faces that student next time. That is sufficient ignominy for the teacher.
But no, this has not taught her a lesson.
Not
taught her a lesson. She went on to challenge the authority. She got emboldened.
The authority, what do you mean by that? What did she do?
The principal has issued a show cause notice. He says, who are you to issue the show cause notice?
Is it that your allegation?
Yes.
Let us revisit that notice once.
Please come to the notice note
Third
at page.
notice. Yes. That's not even your allegation.
Page 55.
Yes. You are directed to explain in writing the reason for questioning the authority of the undersigned, which is the principal, regarding allotment of invigilation duty.
Yes.
So question the authority. What did she exactly say? This is not specific even.
Invigilation duty was allotted to her. She said that you don't have authority to allot this invigilation duty to me.
Question the authority maybe many things. She might have went up and said gone up and said that no, I have some difficulty in
questioning the authority of the undersigned regarding allotment of invigilation duty in examination.
She might have just gone up and said, for all that we know, that I have some difficulty on that date.
No, that is one thing.
We don't know what the nature of this challenge to authority is.
Please come to 56.
Yes, questioning authority may mean
you don't have authority to allot invigilation duty to me. That's the purport of the contention.
Oh, it carries further, accusing that you have not been allotted the duty deliberately by the undersigned.
Yes.
Yes.
গত 25/2 প্লিজ কাম টু 56 গত 25/2/2013 তারিখে আপনার কাছ থেকে একটি চিঠি পাই এর উত্তরে জানাই যে আপনি আমাদের প্রধান শিক্ষিকা আমাদের নিত্যদিনের সুবিধা ভালো লাগা খারাপ লাগার কথা আপনাকেই আমরা সবসময় জানি স্কুলের জন্য কাজ করতে আমরা সবসময় খুব ভালো লাগে এবং গর্ববোধ হয় এমনকি সেটা ছুটির দিনে হলো গত 10ই ফেব্রুয়ারি পরীক্ষার কোনো ডিউটি না পাওয়ায় আমি খুবই দুঃখ পেয়েছি এবং সেটাই আপনাকে জানাতে গিয়েছিলাম আপনাকে কোনো রকম অভিযোগ করা বা আঘাত দেওয়া উদ্দেশ্য ছিল না অধস্তন হিসেবে আপনার কাছে গিয়ে কোনো অপরাধ করে থাকলে তার জন্য আমি ক্ষমা প্রার্থনা করছি
It's a conditional apology.
Yes.
অপরাধ করে থাকলে তার জন্য আমি
Yes, conditional
like the contempt applications.
Yes, which your lordships don't accept.
No.
Which your lordships never accept.
Never accept. Yes.
So I'm not
anyway, so very good.
Dismissal is different from removal in service jurisprudence.
Yes.
One is a complete debarment for employment in future, the other is not. Suppose the school advertisement issues an advertisement for the post. She can apply. And this will also not debar her to apply in other schools. That's the basic difference between dismissal and this other part, the removal. Now please come to page 124. But that 8.75 lakhs paid towards subsistence allowance, that's compliance of the order. But this is in contempt jurisdiction.
Yes. So there you give an unconditional approval. Yours was unconditional.
No, please come to 125.
Yes. We are.
Although the matter is debated as to whether in the facts and circumstances of the case, the removal in fact is dismissal or not, and the letter of 9th February 2021 per se does not say that the said order of removal would not disqualify her from future employment. Having offered an explanation for removing the petitioner from the service of the school based on its rules, we are of the view that the contempt proceeding is not the appropriate remedy. There cannot be any doubt that there was a contempt insofar as release of subsistence allowance which have now been complied with. The petitioner has received a sum of 8.75 lakhs on 13th February 21 towards her admissible dues which she was otherwise entitled to receive prior to the conclusion of disciplinary proceedings. We are not expressing a final view as to whether the disciplinary proceedings stand vitiated for delayed payment of the subsistence allowance and other dues, nor we express any opinion as to whether the removal from service would be a disproportionate punishment considering our earlier order of 2nd August 2019. An unconditional apology has been tendered on behalf of the contempt.
So you are paying the amount.
Yes.
So you have, Mr. Mujumdar, we want to see the last link in the chain. The last, this 9th February 2020, which is the immediate cause of action. Removal letter.
That's 118.
এটা জজ সাহেবকে দিয়ে দিন তো
February 2012, please come to the second paragraph. Therefore, in the month of February 2012, the appraisal form for confirmation of your service was signed by the principal with following statements. 2012 confirmed in service, and 2013 we come up with what things have turned out.
So this was after the previous notices, the appraisal letter? No.
So the
Prior to that.
21.
Prior to that.
Right.
No, not this. The appraisal was of February 2012.
Yes.
So that was
2010 she was probably appointed. 2012.
no. The appraisal was after the first round of notices. That is what you are asking.
No. This is 2012.
2012 was the first round of notices.
That was
First
March
notice was in
2012. March 2012.
After. So this appraisal was before, not that you could have been vindictive.
Yes,
So
before.
not that you were vindictive and yes.
Thereafter, in the month of February 2012, the appraisal form for confirmation of your service was signed by the principal with the following statement.
Because we want to rule out the chance of your.
Yes.
So this was before that, right?
But 2010 she was appointed. 2012 she was confirmed on appreciation of her performance.
March 2012 was the first notice you gave.
2012, yes. 12th March 2012.
So this is before that.
Before that.
Yes.
Regarding the dedication towards improving academic excellence, regarding special qualities or skills, regarding readiness to work beyond stipulated hours, regarding sincerity and promptness, regarding recommendation by administrative heads, on 12th March 2012, show cause notice was issued to you. But I need not trouble your lordship. Then thereafter it goes on to show me the chain of events, the recital. Please come to the last paragraph of that page. Since your joining on 2010, it has been noticed that there have been several misconduct, negligence, inactions from your end which have been reflected in the feedback appraisal form signed by the principal. In addition to this, it was also noticed that there was lack of coordination amongst you and other fellow teachers who were where you failed to take Bengali recitation test and have also not cooperated with the basic school norms. Therefore, based on your repeated and continuous misconduct, negligence, inactions, actions, the school authority was forced to initiate disciplinary action against you, and there was no other option other than dismissing you from your service by a unanimous decision of the Executive Council. You have opted for a procedural irregularity by not preferring appeal under Section 24A of the Anglo-Indian Code against the order of dismissal of 16 July. Thereafter, you preferred writ petition being so and so. Not I skip over that.
Anglo-Indian school code is applicable to which schools?
It is listed school now.
In the memorandum of appeal, my lord, consciously omitted also. No ground. From 20 grounds are there. In the memorandum of appeal, my lord, your lordship kindly.
Why do you say consciously? How do you know? So we will come back and continue with this. Mr. Mujumdar.
না তোমার এটা রাখো।
Yes, Usman.
No. I was placing note that
So the narrative of the case history is given after
page
that.
120. I was placing page 120. No, I was placing page 119. Since your joining on 2010, it has been noticed that there have been several misconduct, negligence, inactions from your end which have been reflected in the feedback appraisal form signed by the principal, grounds mentioned above. In addition to this, it was also noticed that there was lack of coordination among you and other fellow teachers where you failed to take the Bengali recitation test and have also not cooperated with the basic school norms. Therefore, based on your repeated and continuous misconduct, negligence, inactions, actions, the school authority was forced to initiate disciplinary action against you and there was no other option other than dismissing you from your service by a unanimous decision of the Executive Council. You have opted for a procedural irregularity by not preferring appeal under section 20, should be regulation of the code against the order of dismissal dated 16 July 2013. Thereafter, you preferred writ petition. But I skip over that. Thereafter, this was dismissed by the Honorable Supreme Court of India on 25th February, following which you have filed a contempt. But I skip over this. Please come to 121. In terms of directions contained in order of 28 February 2020, you were requested to appear before the disciplinary authority of the school for personal hearing on 23rd March at 5:30 p.m. by an email of 16 March 2020. Thereafter, another email was sent to you on March 22nd, 2020, wherein and whereby you are informed that the personal hearing scheduled to be held on 23rd March at 5:30 p.m. has been postponed till further communication due to West Bengal Government Order of 2020. Subsequently, several communications were exchanged between the school authority and you, which is evident based on the to and from email communications, which further proves that due to lockdown, the school authority was unable to conduct personal hearing during this period. Ultimately, on 21st December 2020, personal hearing was conducted at 5:30 p.m. in presence of you and the Executive Council members. In the said hearing, you were asked in terms of the Honorable Division Bench's directions regarding your expectation or opinion for quantum of punishment from the school authority after admission of your misconduct, negligence, inactions, actions for which you have already apologized through written statement duly signed by you. In reply to the question of quantum of punishment, you have left it on the school authority to decide in accordance with law. And it was agreed by all the Executive Council members present therein, and the resolution dated 21st December 2020 was signed by you as well as by the present members. Now, in exercise of the provisions of the Code of Regulations for Anglo-Indian and other listed schools, as well as on the strength of provisions laid down in Salt Lake School Society Constitution in Regulation 8, the Executive Council of the school authority is empowered to take disciplinary measures such as suspension, removal or dismissal from service against the teaching, non-teaching staff of the school as per government rules for professional misconduct, criminal offences, moral turpitude and any other indisciplinary action detrimental to the institution. Therefore, as the Honorable Division Bench has directed the disciplinary authority to reconsider the matter afresh and has given liberty to the disciplinary authority to pass an appropriate order of punishment, save and accept dismissal, we are of the opinion to remove you from service with effect from 9th February 21. As the Honorable Division Bench has given liberty to the school authority to reconsider your matter afresh and to pass appropriate order of punishment other than dismissal.
Mr. Mujumdar, before we proceed further, please come back once to page 103. 103.
103.
103. The second last paragraph, the division bench judgment.
My lord.
The last few lines, moreover, it appears that there was no past complaint against the writ petitioner. The next line, the writ petitioner could have been left with the caution or reprimand or any other similar punishment, but certainly not with dismissal.
Right.
This was the finding. In this context, you have to consider the matter also.
Now, please, yes, now please come to the next page.
But yes, these are prima facie findings.
And shall not influence the disciplinary authority in arriving at his own conclusion.
Very. So you say this is negated by that. Very.
Now, please have a look at one other important aspect of the matter. Please come to the judgment under appeal at page 137 of the stay application.
Yes.
The first paragraph on that page, Ms. Chumki Chaudhuri, learned advocate appearing for the respondent numbers 4 to 7.
Yes.
Had placed a communication dated 3rd March 2020. The same was taken on record. On the strength of the said communication, she submitted that the petitioner at present is working as a teacher at St. John's School.
Who are the respondents? 4 to 7.
But the school authorities. I just give the designation of those authorities.
Yes.
And the petitioner cannot claim for reinstatement of her service by seeking setting aside of the order, said impugned order of removal. She further submitted that opportunity of hearing was granted to the petitioner. Then please turn over to page 141. The last paragraph. From the said document dated March 3, 2020, submitted by Ms. Chumki Chaudhary, learned advocate appearing for the respondent numbers 4 to 7, it appeared that the same related to one invigilator, namely Indrani Sarkar, for invigilation of the subject mathematics, who was described as an assistant teacher of the said St. John School and was deputed as an invigilator at the said school for ISC 2020 examination. This court has failed to understand the significance and relevance of this document and is of the view that the same had no relevance in the matter. But when your lordships would be considering the propriety of the punishment on the anvil of proportionality, then this is also a very important factor to be taken into consideration.
This could not have been a consideration because this is post facto. After you removed her, she has joined. Now she may have the choice if the removal is set aside, suppose, then she can come back to you.
She can come back, but not.
She may relinquish that job. That may not be a better job.
Right. Now, not your lordships are also considering the fact situation of this case, apropos pages 51 to 55.
But her joining somewhere else does not post facto approve your removal.
No, it controls the relief. It may control the relief.
Why do you say that? I mean,
that's because it's an exercise of discretion. It's not compulsory.
These are not mutually exclusive. Her joining St. John's and coming back to you.
Not had she approached us a civil court.
She had no other option. She had to have a livelihood.
Of course. Now, she had joined. Had she taken recourse to the remedy under the civil law, the civil court redress,
then she wouldn't have joined anywhere by now.
Then not. No. She might have.
She might have still been litigating.
Then what is back wages? Back wages and all these are for the purpose of
back wages after posthumously back wages given.
No. That theory is almost watered down. No. Now, had she been not employed elsewhere, would have entailed a different consequence or a result.
But don't we have to consider as on the day of the punishment being imposed?
But the question is whether the punishment was justified. The second question would be what relief she might be entitled
as of today, yes. The concept of becoming infractuous, but for that it has to be held. We have to hold that these are incompatible. These are mutually exclusive. Her having joined this and that. Now, if you set aside the removal, she may just come back here. I mean, leave that job.
And at the same time, your lordship may be persuaded to hold that since she had procured employment elsewhere, considering this relationship, she may not be brought back.
Yes. All right. So dilutes her relief.
Yes.
Very well.
Now, this is why this back wages and all these things. These are all compensatory.
Yes.
And towards mitigation of hardship, she has taken up an employment elsewhere.
So this was relevant, but the court did not consider it.
Now, 2010 she joined, 2012 assessment of performance, 2012-13 onwards, this relationship has gone to this extent. And in 2026, when your lordship is considering that in the meantime she might have procured an employment elsewhere, that employment might be similar, might not be similar.
All right.
But restoring her back in the school after 12 years to the same post where she belonged or what she held, apropos the length of service of only 2 years.
So irretrievable breakdown of employer-employee relationship. Very well. Yes, Mr. Mujumdar.
These are my sir.
First minute, may I take my lord's kind?
There is a formal affidavit in reply prepared to the opposition.
Yes. Could you match the English?
No, that's.
Minute. Page
Can't be compared even. Incomprehensible. But may I have lordship?
Yes.
Millard, kindly Millard, Come to, my lord, page 68, order, initial order of the Honorable Single Judge, my lord.
In this round of litigation?
In the previous litigation. What was, my lord? It has
Yes.
my lord,
68.
68. May I read?
Please.
Petitioner alleges illegal termination of a service from the school where he worked as an assistant teacher. The name of the school is such and such, run by a society, namely Salt Lake School Premium English Medium Society. The petitioner states that she was appointed as a teacher of the said school 30th March such and such. Her date of appointment has been shown as 1st April 2010. Her service has been terminated with effect from 16 July 2013 by a letter dated 15 July 2013 issued by the school, signed by the secretary of the school. From the affidavit in opposition filed by the school, the respondent number 4, it is found that the petitioner was initially appointed as a contractual teacher from 29th August 28 to 31st March 2009, which was renewed from such and such to 31st March 2010. And finally, from 1st April 2010, the petitioner was appointed as an assistant teacher in primary section in the primary scale of pay band. The petitioner has stated that her service was governed by the provisions of the Code of Regulations for Anglo-Indian and Other Listed School 1993, which has not been denied by the school in its affidavit in opposition. Kindly note this point, my lord. And thus, it is an admitted position that the school is regulated by the Code of Regulations for Anglo-Indian and Other School 1993, the code in short hereinafter. The petitioner has submitted that she was a confirmed staff of the school and without following the procedure laid down in the court, her service has been terminated without holding a disciplinary proceeding as mentioned in the said code for disciplinary action against the confirmed staff. My lord, kindly also take note, my lord, of this point because, my lord, your lordships know, my lord, the disciplinary proceedings commences on and from the date of issuance of the charge sheet. Admittedly, my lord, show cause was issued. After my response, my lord, there was no issuance of charge sheet. As such, in the eye of law, there was no disciplinary proceeding. That is a point of law, my lord, which is admitted. From the records would reveal, my lord, there was no disciplinary proceeding.
All right.
May I start, my lord?
Please.
তুমি বসো না ভাই। Petitioner has also alleged that she was not given any class in the academic year 2013 and she has disclosed a letter of teachers representative dated 3rd April 2013. In the said letter of teachers representative of the school to the president of the school, such and such has been written, Mrs. Indrani Raha Sarkar, one of the popular teachers of the morning section, has been allotted no class at all, which is one of the mental torture. We as teacher representatives strongly object to this type of humiliation to a teacher. We apprehend a conspiracy against her. From the read petition, I find that on 13th February 2013, a letter was given to the petitioner by the principal of the school in respect of not taking the Bengali recitation test of a student, class 1C, which was to be taken on such and such, was not taken till such and such. In the said letter of explanation given by the petitioner in this respect was recorded, but the principal found some difference between the petitioners and the student statement. However, the principal directed the petitioner to explain in writing, justifying the position of the petitioner and why any action would not be taken against her by the school authority for the said affidavit. No document has been disclosed by the school in these proceedings to show that in this respect any disciplinary action was taken against the petitioner. A letter of the president of the school dated 8 July 2013 has been annexed to the writ application, wherefrom it is found that a disciplinary proceeding was initiated as per resolution adopted on 20th April 2013 in the meeting of the executive council of the school, etc. And the petitioner was directed to appear before the president on 11 July 2013, 5 p.m. for presenting the petitioner's version. From another annexure of the writ application, which is a letter of secretary of the school dated such and such, the following is found from the first paragraph thereof. The inquiry committee before which you appeared on such and such date at 5 p.m. had found your reply unsatisfactory, and in the EC meeting held today, it was unanimously declared that your service as teacher has been terminated with effect from 16/7/2013 without any charge sheet, without any inquiry. A misconduct means a proved inquiry upon minute inquiry of a confirmed staff. An entire omission, my lord. And such omission, my lord, is a total aberration of law. Kindly comes to, my lord, next. From the affidavit in opposition of the school affirmed by the school stand as to the confirmation of the petitioner's service comes to light. In paragraph 9 of the affidavit in opposition, it has been stated inter alia that her service was not confirmed, that the several complaints have been received in violation of the employed code of conduct. Still, she was allowed to continue her service by the school authority, and thereafter, in view of her insubordinate attitude and false labeling of allegations against school office bearers, she was issued letters for asking for explanation and disciplinary procedure was initiated. No disciplinary procedure. Respondent number 4 craves leave to produce the entire case record relating to her service tenure in the school at the time of hearing. No record of disciplinary proceeding has been annexed to the affidavit in opposition of the school authority, nor any such record was produced before the court at the time of hearing of the matter. The school submitted at the time of hearing that everything would be clear from minutes of the meeting of the Executive Council of the school dated February 20, 2010, and it was directed to be produced by this court, which was produced before this court on 18 February 2019, but absolutely nothing becomes clear from the said minutes of the meeting. Copy of the minutes of the meeting has been taken on record. Now, two questions arise for consideration by this court. These are whether petitioner's service was confirmed in a school as a teacher, whether her service was terminated after holding a disciplinary proceeding against her following the said code. For deciding the first question, the appointment of the order dated 30th March 2010 issued by the school to the petitioner is to be considered. Relevant part of it states she will have to undergo a probation period of 2 years from the date of her joining. In case of an unsatisfactory performance during the probationary period, the authority reserves the right to terminate her service, giving her 1 month's salary in abundance. Her confirmation in the service shall depend upon her overall performance and behavior after completion of 2 years in probation. Her service after confirmation can be terminated on issuing 2 months proper notice on payment of salary of 2 months in lieu thereof on either side. Normal service rule codes which are applicable to any teacher, government recognized affiliated delegating or schools, including our code of conduct, shall be applicable in her service matter. Prolonged and a frequent absence without an intimation and without reasonable grounds, an unsatisfactory performance may lead to termination of service without assigning notice. From the said relevant part of the appointment order, it is found that the petitioner was placed for a probation for a period of 2 years and confirmation was dependent upon her overall performance and behavior after completion of 2 years in probation. No document has been disclosed by the school before this court to show that overall performance and the behavior of the petitioner were not satisfactory, and thus those were intimated to the petitioner during 2 probationary period. Now, clause 21E of the said code is required to be considered, which is as follows. Ordinarily, a teacher appointed against a permanent vacancy will be placed on probation for 1 year from the date of appointment, and such probation may be extended by no more than 1 year thereafter. In all cases, teachers appointed on probation are terminating the service and extending the period of probation, as the case may be, shall be served to him, her 1 month before the end of the probationary period, failing which the teacher will be deemed to be confirmed in that appointment. From the above regulation 21E, it is found that a teacher appointed in a permanent vacancy would be placed on probation for a 1 year.
Confirmation is probably not denied by
Denied
Mr.
by the-
Majumdar
right,
also. So
right.
they're
So, Millard, last part, regulation 24, Millard, page 76.
Yes, right. The second question.
Second question. Regarding second question, regulation 24 of the code, Millard, 1993, it's a statutory code, Millard. It's procedure for disciplinary action against confirmed staff. The head will frame charges. At the outset, I submitted, Millard, after giving sufficient warning the basis of allegation against staff, and will bring immediately to the notice of managing committee. No warning, however, will be necessary for gross misconduct. The chairman of the managing committee will appoint a person to conduct an inquiry. The employee shall be supplied with a copy of the charges together with a statement of allegations on which the charges are based. Millard, absolutely absent. She will be required to submit within 10 days of the receipt of the charges or statement of allegation and a written statement to the inquiry officer. Millard, these are the procedures. So, Millard, these procedures have to be complied with. Now, Millard, ultimately,
Page 78.
then Millard, page 78, 79, Millard, I hold there was no disciplinary action. 79, Millard, I'm sorry. I hold there was no disciplinary action under the said code against the petitioner who was a confirmed staff. Instead of following the regulations such and such of the school has been referred to by a letter dated, her service was terminated. The school has reasons based known to it, did not care to follow the provision of the court in this regard, which the school was and bound to follow. Therefore, the second point is answered accordingly. Millard, service, therefore, Millard,
So before any penal action,
and
there has to be a disciplinary.
right. Now, Millard, the misconduct, negligence, Mr. Majumdar, my learned senior friend, had read, it has to be proved misconduct upon inquiry. There is no other way.
It's a friendship band.
No, Millard, yes.
Yes. But please continue, sorry.
Yes.
It was a distraction, that's it.
Now, Millard, for the reason, the friendship, they have sent, sorry, Millard, the termination was set aside. Termination was very difficult, Millard. For the reasons the dismissal order was school dated such and such of the petitioner with effect from its status and quash. It is evident from the pleading of the affidavit in opposition used by the school, there was no such serious dereliction of duty on the part of the petitioner for which disciplinary proceeding could have been, which your lordship Miller pointed out to Mr. Majumdar that it is shockingly disproportionate. Shockingly disproportionate.
Not say shockingly, but disproportionate.
Disproportionate. Now, Millard, if it is why it is disproportionate, the school had admitted this.
Yes.
Now, Millard, the division bench order, page 103. Kindly, Millard, starts, Mr. Majumdar, my learned senior friend, starts from the disciplinary authority.
Mr.
I will
Majumdar placed this.
But not from the first, second one. Millard, second paragraph, we accordingly direct the disciplinary authority to reconsider the matter afresh. So it is a direction, Millard, not an observation. It will open to the disciplinary to pass an appropriate order of punishment if the disciplinary authority so desires, save and accept dismissal. Kindly read this order with the third paragraph, last lines. The petitioner could have been left with the caution or reprimand or any similar punishment, but certainly not with dismissal.
Mr. Majumdar says that this entire thing is diluted by the last paragraph.
Yes, last paragraph, the judgment, as period of and the judgment, yes. It says when the judgment of the stand modified, however, this observation is prima facie and shall not influence the disciplinary authority.
However, this observation is prima facie and shall not influence the disciplinary authority in arriving at its own conclusion.
Yes, Millard, but
so it can arrive at a conclusion contrary to these findings also.
Yes, my respectful submission that Mr. Majumdar's understanding, Millard, subject to what my lords will say, Millard, this observation is prima facie. Millard, it contains direction. Direction is not observation. What is the observation in the order? At base, Millard, the
direction was only
that it will open to the
consider and pass
a punishment or if the disciplinary authority so desires.
Except dismissal.
Except dismissal.
But the rest are observations.
And reconsider afresh.
Could have been left with the caution or reprimand, but certainly not. Could have been and all these
could have been, Millard, could have been, according to Mr. Majumdar, the last line diluted because it is an observation. Because if it is, my respectful submission is that could have been left with the caution, Millard, that Millard in the punishment, that is also, Millard, based on the facts of the case, the court's desire is this. Whether, Millard, such desire, Millard, is relatable to the paragraph number 2 of page 79 and Millard this. Millard, there must be a harmonious construction, Millard. There cannot be a selective understanding of the last paragraph in order to justify, Millard, his guilt. Now, Millard, question
so direction should be read with this.
With this. Otherwise, Millard, there is no meaning. There must be a logical link, Millard. Otherwise, the judgment, Millard, cannot be read in isolation. And Millard, the school authority, Millard, suffers from, Millard, because absolutely, Millard, the affidavit in opposition, the Honorable Single Judge said, it never says it is a dereliction of duty. Dereliction of duty is a misconduct.
So you say the direction should be read in proper perspective.
Proper perspective.
Reading this into that direction.
Yes, Millard. Otherwise, Millard, judgment has to be read as a whole, Millard. Otherwise, not in a fragmented manner. Now, Millard, these cannot be segregated from the last paragraph.
All right.
Number one. Number two, Millard, that I accept, Millard, the proposition of law, what Mr. Majumdar, my learned senior friend, has read, Millard, taken so much of time, Millard, that all the judgment says writ is not maintainable. Entertainable, he lastly said. Now, Millard, the maintainability and entertainability toward discretion, because your lordships have a plenary power and discretion must be informed by reason.
A distinction has been drawn in the judgment last cited by Mr. Majumdar, that which says that yes, private school discharges public functions vis-a-vis the students' education. But inter say the teacher and the employer. I mean, it's a private contract of employment and it has to the aggrieved party has to go to the appropriate forum.
Yes.
What do you say to that?
Yes, Millard, this is, Millard, if your lordship kindly take the memo of appeal, the single judge has categorically said in the division bench that the regulation 1993 is a law. This particular statute, Millard, governs the employer-employer relationship. There is no private master contract relationship, Millard, contract. This relationship is governed by regulation 1993. And in the appeal, there is not a single whisper.
That Anglo-Saxon code.
That Anglo-Saxon code, Anglo-Indian code. The code of regulations for Anglo-Indian and other listed school. Millard, I'm sorry, I am not armed with the 2 copies. Millard, kindly pardon my inability.
No, you choose the judge and the other will pass the judgment. Give it to one of us and the other will pass the judgment. No, need not. It is quoted in one of the judgments.
So it says, Millard, that in exercise of the power,
the last order,
Justice Gangopadhyay's order has page 68, possibly, Millard, 68.
Yes.
In exercise of power, by sub-regulation 2 of Regulation 1 Code of Regulation of Anglo-India 1993, published under it's a government order, my lord, by order of the governor.
Yes, yes.
Under Article 309, it is sorry. Left hand side, my lord.
You can do that. Thank you. Yes.
So, my lord, Honorable Single Judge, Regulation 24, my lord, kindly. Regulation 24, this has been quoted. So, this is issued by the governor. Now, my lord, now, my lord, kindly comes to the memo of appeal. Memo of appeal to
So it's an infraction of a statutory
it's immaterial whether yes. I said, my lord, additional grounds to them. He said, my lord, the additional ground of appeal. He says, my lord, kindly comes to this.
But their grounds do not govern the law.
No. There
cannot be any estoppel against the law.
No.
Or
there
in
cannot
favor
be.
of the
I
law.
said, my lord, that this point, Mr. Majumdar's client, my lord, was, my lord, had the opportunity to deal with this point, but they waived this right. The point of law was never argued, the point of maintainability, that the applicability of...
So that will come to, that's a different point.
Yes.
But first, let us find out whether this maintainability, I mean, it's maintainable or not.
Why it is maintainable? Because even if it is a public school, when the master-servant relationship, he said, my lord, that it is a private school. I said, my relationship with the employer governed by this Anglo-Indian code.
Which has statutory force and therefore it's an infraction of a statute.
And yes, immaterial, my lord, whether this is a private school or not. And none of the judgments, my lord, deal with this particular provision, that what is the ramification of this regulation which applies to us.
Very well. And regarding maintainability point, whether they can now agitate.
Whether Section 11, subsection 5 of the Code of Civil Procedure.
Subsection 5.
11.5, my lord, explanation. Sorry, my lord.
Yes.
I cannot, my lord.
No, we can and you cannot. You have a phenomenal memory.
No, my lord. Phenomenal memory, no, my lord. Yes. I may be wrong, my lord, kindly, my lord.
Well, photographic memory. If you would prefer
11,
memory, you can say
11.5, it says, my lord, point raised, but court did not answer. It's a rejection. And my lord, question is,
no, Mr. Mujumdar's
it's
point
a constructive res judicata, the point available.
If you can ask the question.
Sorry.
Yes.
Sorry.
Mr. Mujumdar's point is not constructive res judicata. Constructive res judicata we raised, but he says that it's a question of law. If it's a pure question of law, Supreme Court, law laid down by Supreme Court, Honorable Supreme Court. Now, if it's a pure question of law, whether they can waive that right.
The question is, my lord, that here, my lord, even if it is a wrong order, it binds the parties. Number one. At that point of time,
they're not reopening that order. He's saying it's a different round of litigation. This is a proposition of law.
It is a continuation of that proceeding because no new charges, no new show cause, nothing. But I said the point was available. I said that they did not raise the point. I said, my lord, this point was never raised in any of the judgments where and disciplinary, and there is a clear aberration. I said, Regulation 24, this point has never been answered. He never said that the judge has committed a wrong, fell into an error by adverting to regulation, because statutory regulation violation, even if it is there, then read does not apply, maintainable. If it is a question of maintainability, in none of the judgments, this point was answered and raised. It is not a question of a public duty only. In a cooperative society, read does not lie. But if there is a statutory violation, then also the court says, it applies. Arjad Ali Ghazi, 84 CW and possibly 10484. Arjad Ali Ghazi. Now, first point is, that Regulation 24, it talks about a disciplinary proceeding. Disciplinary proceeding commences with the issuance of charge sheet. 24A Regulation 1993, it demands, there must be an inquiry, statement of allegations, charges, inquiry officer, natural justice. Nothing has been done. Number two, that Mr. Majumdar's client cannot, take a different route from that of the orders, that was passed by the two different bench and the coordinate bench. Third, that in none of the judgment, he has not raised any point, at least in his argument, or shown the paragraph, which says that even if it is statutory violation, the writ is not maintainable.
So on merits, 2 points. One is that there was no initiation of disciplinary proceedings in the eye of law. No charge sheet, nothing.
Yes.
And secondly, division bench direction has to be read in the light of its proper context. If so read, they
Yes.
cannot again do a similar thing. It
Yes.
has to be on a footing of censure at best.
Censure, at best.
And on maintainability, you say that they first of all they cannot reopen this issue, having waived it all along. And secondly, statutory infractions, so it's maintainable also otherwise.
And Millard, the maintainability point, even if it assuming, not admitting that was argued, Millard, available, that maintainable, not maintainable, with regard to this, that Millard,
No, whether it's a pure question of law.
it is a pure question of law. Today, Millard,
Whether it's
today,
a pure question of law, we have our
no,
doubts
no,
on that
no,
also.
Millard, I say that pure question of law, but the point
Because it
of law,
depends on the facts of the case.
Millard, he did not address, yes, in the facts of the case, he did not address, Millard, this point of law, that he should have answered that whether this violation, he never said so. On any of the proceedings, number 1 thing. Now, Millard, I am seeking, Millard, subject to correction, Millard, whether I am correct in submitting, Millard, that is my understanding, that when I come to a writ court, Millard, I am seeking, Millard, the enforcement of legal rules. Legal rules mean, Millard, that binds the relationship with 24A. Millard, if that is so, Millard, that enforceability of law, Millard, cannot be equated with the comparison that section 14 of the Specific Relief Act. There is a pure private employment today. There, Millard, when I say there is a breach of commitment, only compensation, and wrongful restraint, only compensation, section 73, subject to correction of the Contract Act. Now, Millard, today, here is on a different plane. Here, Millard, the court has categorically recorded that there is no dereliction of duty. Page 51 to 55, Mr. Majumdar has read. Millard kindly sees that what is the nature of misconduct, whether the every failure in life, Millard, amounts to misconduct, or, Millard, something, Millard, which attracts disciplinary action. Here, Millard, sorry, Millard, I stop here. Millard, this is, Millard, the court 51, Mr. Majumdar has read. What is the letter and what is my answer? আমি ছাত্রীটির মুখ মনে করতে ভুলে গেছি.
Initially, you denied.
Initially.
Student came with her parents.
Came.
And then you were called up.
I
and
did
then
not.
You admitted.
Mr. Majumdar's question is, submission is that ultimately I was forced to admit. On the other, I can take in a different way. I said that when a child comes, he or she is like my son and daughter and son. But I said that I felt that she should not have been embarrassed before his or her parent. I said
something into
the question is, Millard, where is
never even pleaded that.
Millard, question is, where is the disciplinary angle in this matter, far less to speak about misconduct. And if I admit, Millard, if it is a misconduct, then it has to be a proved misconduct. You bring your witness, you give me a charge sheet, I should be given an opportunity of hearing. The principles of natural justice, Millard, is, Millard, implanted, Millard, in the Constitution as well as, Millard, in any rule. Here, Millard, the rule is very specific. You must give me an opportunity.
If we accept that submission of yours, Mr. Basu, then the entire the removal goes. Mr. Majumdar has taken a point that you have joined another school.
No, Millard, here, Millard,
so
absolutely, Millard, Mr. Majumdar has also said that I question the authority. The question the authority in a legal manner is my inherent right, comes from the Constitution.
Yeah, we agree.
Yes. Now, remember,
the manner in which you question the authority, that is important. They have not alleged anything on that.
Yes.
No, actually,
yes,
they have not alleged anything.
Not
you were rude or something like
yes.
That. No, but you have joined another school.
No, but question here is my
joining litigation. Is Millard,
joining in my school, Millard. That is, if it is a survival, then I am not entitled to get my back wages. So, it does not prevent me from, Millard, questioning, Millard, the propriety of the order.
No, but if you joined, Mr. Majumdar has a subtle point also here. Back wages is to compensate you for the loss you have suffered.
Yes, Millard, ultimately.
If you have joined another school and you have earned livelihood,
no.
Why should back wages be given to you? Like we retire and take some other job.
No.
Do you get pension?
No, Millard, question here is that is not relatable to this issue, Millard, subject to correction. Why I say, subject to what my lord will say. Millard, that the propriety of this order, because this particular, Millard, removal from service, which based on certain allegation, Millard, it carries stigma. And, Millard, my right to dignity, Millard, that is also, Millard, that is an onslaught on my right to dignity.
He has taken a point that removal and
removal, Millard, yes, Millard, that is, Millard, but removal and dismiss is ultimately, Millard, that I was forced to segregate myself from the relationship. One is, Millard, disentitle me, Millard. The proposition of law is correct, that I am not entitled to get a future employment so far as dismissal is concerned. I am removed. But question is, Millard, that similarly like punishment, that is, Millard, page 103, kindly,
So that is a different argument we have
Yes,
recorded there.
yes, yes. If that is so, my lord, this cannot be segregated from this. This has to be adjudged in the context, because in law, my lord, everything is with reference to context. Now, my lord, if I may say so, that the entire judgment has to be read, then, my lord, it automatically, my lord, has some ramification or bearing on the next understanding of the law, my lord, declared by Justice Ray, the Honorable Single Judge. Now, my lord, this particular aspect, the joining my school, it only, my lord, disentitles me, my lord, because the stigma which I carry, my lord, for the whole of my life, that I was, my lord, removed from a school, my lord, that is also, my lord, it carries something. And, my lord, only, my lord, here,
Why this bunch?
my lord, this is, my lord, yes, I'm
On what
giving,
proposition?
something, my lord, is not, it is scattered, my lord. My lord, here, my lord, I have, my lord, Doctor, the 1992, 2 SCC, my lord, I will rearrange it for your lordship, give me 1 day time, my lord.
Only the relevant.
Yes, yes. Dr. Dattatreya Mahadev Nandakanri, Municipal Corporation, 1992.
Pagination also, no
In
pagination.
this one, I will do it. আজকে এগুলো করে নিন, কোনো সাথে বসে। 1992, 2 SCC, page 547. Milord, I am only reading, Milord, that it refers, Milord, in paragraph 7, SR Tiwari.
Wait once.
Fine.
Let us find it out from here.
1992 SCC আছে।
What is the name?
Dr. Dattatreya Mahadev Nandakarni versus.
Part of this compilation?
দেখতে বার করলাম না?
Yes, yes.
Fortunately, yes.
Easy.
Paragraph 7. I got it. In SR Tiwari District Board, Agra, is it recorded? It starts from, my lord, it has been observed, it is settled law.
Para 7. It is settled law.
It is settled law that form of the order under which the employment of a servant is determined is not conclusive of the true nature of the order. The form may be merely to camouflage an order of dismissal for misconduct, and it is always open to the court for which the order is challenged to go behind the form and ascertain the true character of the order. If the court holds that the order, though in the form of merely determination of employment, is in reality a cloak for an order of dismissal as a matter of punishment, the court would not be debarred merely because the form of the order in giving effect to the rights confirmed by salutary rules upon the employee. Now, my lord, my lord, the question is, my lord, it is the form. It's a camouflage. Because 120 page, my lord, Mr. Mojumdar, my learned senior friend, had extensively read, my lord, for your lordship's consideration. The narratives of the order, my lord, the genesis, it clearly indicates that my conduct is deplorable. I was cautioned. So there is a stigma, my lord. So today, my lord, whatever may be the language, my lord, even if it is a dress of our thoughts, my lord, ultimately it's a form.
It is a, sorry?
Sorry, my lord.
Even if it is a play, we followed.
No,
please repeat that.
Language is the dress of our thoughts, my lord.
Language is a dress, yes.
My lord, kindly do not. Kindly, my lord.
So what would silence be then?
No. I'm sorry, my lord. I will not. No, my lord, kindly say.
You silently think something. So.
No, nothing.
Yes.
My lord, only. And my lord,
What are the other judgments?
St. Mary's.
Yes, St. Mary's has been
St. Mary's was read, my lord.
Yes.
Satimla Sharma versus, my lord, St. Paul Senior, 2011. Last judgment in the compilation, Satimla.
Satimla.
Satimla was not considered in, my lord, St. Mary's.
And this is not the last judgment in the compilation.
Sorry.
Yes.
Yes,
yes, 2011.
2011, 13 SCC,
Yes,
760.
Right.
In paragraph 25 to 27, my lord, kindly comes.
2011, 13 SCC.
13 SCC, 760. Paragraph 25 to 27. My lord, I only, my lord, I am said, my lord, the claim of parity of salary and allowances with the teachers of the government school, and there was no salutary provision. The court says, my lord, that there is a provision of regulation which provides for such parity. My lord, Satimla said that the involved prayer for parity of value in the regulation was, I said, my lord, salutary regulation was relied upon. This judgment was not considered in St. Mary's. Parity Article 14, discrimination Article 14, arbitrary decision Article 14. Now, my lord, I say that, and also there is a judgment, my lord, of your lordship's court, my lord, I do not know in the compilation, I will check, my lord, I will give only, take, my lord, only 1 day time. That, my lord, no, the application, the code was not. Milord, Kaushik Majumdar's case, Milord, in MAT 1949 490 of 24, in this judgment, Milord, the Honorable Division.
In this compilation.
This is Milord, they relied, Milord, earlier, Kaushik Majumdar. Right? Kaushik Majumdar versus State of West Bengal, MAT 490.
Not relied today.
Yes. Last occasion we did rely.
This occasion, Mr. Majumdar has not cited.
No, they relied on this, Milord. Today, Milord, he did not place.
Today he did not place. We'll consider only what he played
Yes,
today.
Milord, I said, Milord, it is important for the simple reason that the aspect of applicability of the regulation, Milord, was never considered in none of the judgment. This is on the score, Milord, that in a private school. So, Milord, Milord, and lastly, the Honorable Single Judge's order, Milord, which is under challenge, Milord. That is, Milord.
So you are relying on only these two judgments, 1992 and 2011-13.
Milord, only the estimate. Ayub Khan versus State Ayub Khan Nurak Khan Pathan versus State of Maharashtra 2013 4 SCC 465. একটু আছে কিনা দেখবেন আছে তো দেখে নিয়েছো তো তুমি নিজে
Who will see whether it's there?
I told him.
Is it there, Ayub Khan?
Para 9.
On what proposition, Mr. Basu?
Milord, violation of legal rules, Milord.
Achha.
It is a settled legal proposition that a stranger cannot be permitted to meddle in any
paragraph?
9. Sorry, Milord.
Right.
It is a settled legal proposition that a stranger cannot be permitted to meddle in any proceeding unless he satisfied the authority court that he falls within the category of the aggrieved persons. Only a person who has suffered or suffered from legal injury can challenge the act or action or order in a court of law. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing a salutary or legal right, or when there is a complaint by the appellant that there has been a breach of salutary duty on the part of authority. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which the jurisdiction is restored to. The court can, of course, enforce the performance of a salutary duty of a public body using its jurisdiction at the behest of a person, provided that such person satisfy the court, he has a legal right to insist on such performance. The existence of rights is a condition precedent for involving the jurisdiction of the courts. It is implicit in the exercise of such jurisdiction. The relief prayed for must be the one to enforce a legal right. In the fact, existence of such right is the foundation of existence of the jurisdiction of the court. So, a legal right means an entitlement, paragraph 10. A legal right means an entitlement arising out of legal rules. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law.
Yes.
So, Milord, this is my understanding. So, Milord, I sum up.
The Supreme Court, sir. So, little different.
Now, Milord, the order under appeal.
Every time you'll end with a judgment, we'll ask you whether there is any other judgment which you like.
No, Milord, sorry, Milord.
Three judgments. No, we are not putting any pressure on you. Can cite other judgments also. Are you?
Jaggata dekhi debo. Jaggata dekhi, huh? Milord, whether I only say, Milord, that this is has the force of law regulation 20. So, Milord, for which I need not, Milord, cite any judgment. Even then, Milord.
For the self-same, this code.
The Supreme Court, Jaggas.
In regarding, with regard to the self-same code.
No code. Under the CBSE bylaws, it says the bylaws, Milord, they're there. I only, Milord, only one judgment, BM Minha's case, Milord, paragraph 2384 Supreme Court, possibly the first one.
Yes.
If I'm not wrong. BM Minha's paragraph 23.
This is on what proposition?
This is on proposition that in that cooperative society or society registration act, even if there is a bylaw, that bylaws have to be adhered to. Milord, kindly see the paragraph 23. Even if they don't have statutory force. Even they do not have any statutory force. Paragraph 23. ওটা বার করো না তাড়াতাড়ি। ছিল তো। আর 84 Supreme Court এটা আবার এই compilation.
But this is somewhat different from the present case. Sorry.
When I go to that extent.
These are not the bylaws of the school.
I said it takes us on a higher pedestal that even if my case is worse than that of this, so far as the regulation. Suppose there is no regulation. Only bylaws is there.
That is a different prospect altogether. The organization itself has bylaws, it's bound by it.
Yes.
Here it is not such a case.
Yes. Milord, so Justice Milord, Honorable Single Judge.
Yes. So, but if you accept that submission of yours, Mr. Basu, that there was no disciplinary proceeding in the eye of law, we'll have to give them leave again to
No, my lord,
initiate
today,
a
my lord,
disciplinary proceeding.
today, my lord, it is too late in the day. Because in a second round litigation, whether, my lord, this, my lord, I say, my lord, that today they, my lord, missed the bus. The court had directed, they did
At
not.
the same time, we cannot grant to set aside the removal, thereby virtually reinstating you. That will be, the effect will be reinstating you. And also not give them any.
My lord, today, suppose, my
They've
lord,
already left the job.
my lord, today, kindly, my lord, have the charity to consider one aspect, that 2012, 2013, the student who was in class 5 or 8, after 13 years, my lord, the witnesses are also necessary. The contemporaneous stone has lost. I have severed myself, my lord, for many years.
So therefore, if we do that now, they'll be losing that opportunity to
No, my lord, kindly cease.
get advantage on both counts.
No, I say, my lord, that I will take the benefit of the law for the simple reason that this 13 years time, my lord, it clearly, I had to undergo an ordeal. Now, my lord, such, my lord, omission on the part, my lord, they are the institution. I'm an individual. So, my lord, the question here is, when there is no dereliction of duty, when the court said that there is a statutory violation, when the court said that 51 to 55, which he has read, 120 page, my lord, he has read the entire narrative, which, my lord, before kill a dog, give it a back name, my lord, then, my lord, fire. So, my lord, this 120, my lord, and Mr. Mojumdar said that judge decides everything, my lord, prior to the hearing. That is not the case, my lord. The case is, my lord, that is, my lord, a kind of a hearing which is, my lord, the arranging the prejudices and bias. And why should I take this institution like this, my lord? Number one. Number two, my lord, the court had said, now, my lord, the paragraph 140, page 141, my lord, of the my lord, order under appeal. Now, my lord, from the impugned order, page 141. Page 141 of your lordship's brief. From the impugned order of removal, dated February 9, 21, it also appeared to this court that the school authority had exercised power in terms of Regulation 8G of the Regulation of Association of Salt Lake Society, for short, and issued of the impugned order of removal dated February 9. Regulation 8 of the said regulation provided for the powers and function of the council. Sub-regulation G, Regulation 8 inter alia provided that council, being the deemed the managing committee of the school, can take disciplinary measures. Such suspension, removal, dismissal, service against staff as per the government rules for professional misconduct, criminal offense, moral turpitude, or any other indisciplinary action detrimental to the institute. On the previous read, it finally decided the dismissal from employer was disproportionate against the purported challenges against the petitioner, and the dismissal order was set aside. From the said document dated March such and such, submitted by Chumki Chaudhuri, appearing for the related to investigator Indrani Sarkar, subject mathematics, who was described. Indrani Sarkar was never, my lord, a subject teacher of mathematics. Of the said ST, John School, was deputed as an invigilator at the said school for ISC 20 examination. She is a teacher of Bengali, my lord. This court has failed to understand the significance and relevance of this document. In view, the same had relevance no matter. Inasmuch as the petitioner was described as an employee of St. Joseph in event, no step of removal from the employment of school could have been taken. If this communication is taken to be correct, in that event, Salt Lake School could have not have issued the said impugned order of removal against the petitioner. From a meaningful reading of the Regulation 8 of the regulation, this court is of the firm view that provisions of natural justice, by granting an adequate, meaningful opportunity to delinquent employer, were inbuilt in the regulations, which ought to have been granted to the petitioner free from any doubt and in a clear manner. In such event, where the impugned order removal was challenged to this writ petition, it was a duty on the part of the relevant school to demonstrate.
But you joining St. John's School before your removal, you were removed on in February 21. You had joined St. John's before that.
That is, my lord, that is what, my lord, they are saying. Yeah.
After dismissal, first round.
Dismissal.
First round after, yes.
Yes. First time.
And how could you remove him?
Initially, she was dismissed.
If she had joined St. John's, how could you remove him?
From our school.
Yes.
Now, my lord, here, my lord, the court had said ultimately, firm view, that such an adequate and meaningful opportunity of hearing was not made available to the school by the authority. There was no disciplinary proceeding, my lord. which I said, Milord, at the outset, Milord,
Yes.
and the February annexure session. In view of the career concern, there was no order of removal suffered by the petitioner at all, and service benefit should be calculated. The petitioner shall be reinstated by the school within 48 working hours from the date. This order shall not preclude the authority to proceed against if it is so advised, but strictly in due process of law after taking all steps. So, Milord, I summarize my argument.
Have you actually joined St. John's? Otherwise you'll have to, because if you affirm this order, if you dismiss the appeal, then we affirm this order, this will remain. This remains.
আমি জানি না, আমাকে লিখিত ইনস্ট্রাকশন, আমি এরকম বলতে পারবো না। আমাকে লিখিত মক্কেল ইনস্ট্রাকশন হলো, may I get one
She
day?
joined St. John's and was removed from there also. Then what is the complication?
No, I don't know. I said, well, I said talk to the client and ask her to give a
No,
written
because if you dismiss the appeal, even then we have to confirm this. So this will remain.
No, Milord, that is where, Milord, I say whether it is. আরে নিয়ে আসুন না written instruction, কালকে সকালে নিয়ে আসুন।
What is his oral instruction?
No, Milord, kindly, Milord, give me one day
What
time.
does he say? We are now curious.
No, no, Milord, he said, Milord, possibly she has joined, but I do not know that.
When? If so, when?
Date neven, প্রমাণ নেবেন। May I get one day time, Milord, tomorrow?
For that only, yes.
For that only, yes, Milord. Now, Milord, first of all, that today, Milord, if the court directs, Milord, after 2012, that the disciplinary proceedings, all witnesses, Milord, contemporaneous tone, Milord, lost. Today, Milord, there is no point. Milord, court always takes a, Milord, pragmatic view, Milord. Milord, it is not only always a logic, but an experience, Milord. So, Milord, if that is, Milord, if that is so, Milord, today, Milord, there is no point. Number one. Number two, Milord, the order itself reflects from the affidavit, from the record, and when the termination order, Mr. Mujumdar, my learned senior friend, had read, Milord, all the narratives, Milord, leads to only one path destination. That is, Milord, my conduct, assessment of conduct, proved misconduct without any inquiry, which itself shows, Milord, the bias on the part of the authority. And, Milord, the insubordination part, I challenge the authority, Milord, Mr. Mujumdar, who had become a mouthpiece of his client, Milord, the creature of instruction, Milord.
What are you?
No, yes, also. Milord, he said, Milord, with all fairness, that, Milord, he questioned the authority as if, Milord, we live under the monarchy. I always question. Suppose, Milord, tomorrow I question your lordship's order in this.
Every day you do that.
Yes. So, Milord, today, Milord, it is my right. Number three, Milord, the first 20
Do
grounds.
it outside the courtroom, it's your right. You do it inside, it's very wrong. Anyway, so you do it, so they can also do it.
Yes,
Get the
my
logic.
written notes of argument is possibly there.
Written notes of arguments are also there.
জমা দিয়েছিলেন আগের দিন? করেছিলাম তো। Justice Standard, Milord, heard this, Milord, with Mr.
It's not there. He's saying it's not there, you're saying it's.
এই তো আমার তৈরি আছে।
Compilation of judgment দিতে বলেন।
Compilation of judgments are
তৈরি
there,
করা আছে।
out of which most are irrelevant.
Judgment
না, compilation না, written notes তৈরি করা আছে।
আমাদের judgment
এই তো final written notes.
আজ পর্যন্ত কি compilation?
Milord, tomorrow I will rearrange this for judgment. I will take out, or not required.
Need not.
Yes.
There
So, Milord, today, Milord, my joining in the school, Milord, does not preclude me, Milord, from challenging the order, Milord, of the termination. Number one, it's not standing on different footing.
Yes.
Third, Milord, the last point, Milord, that Mr. Mujumdar, the point of maintainability, the constructive resolution. Yes. Now, Milord, today, and 103, 104, Milord, has to be read as a whole. And Justice Gangopadhyay's order, Milord, was modified only to the extent that court did not disturb the finding that there was no violation of a salutary rule. If that remains, Milord, possibly, Milord, this issue cannot be reopened. Yes, Milord, that is my. Naam.
What will be the effect if we set aside the removal sub? If we affirm this order?
Automatic reinstatement.
Because this order says they can again reopen this issue.
No,
we have to modify that part.
No, Milord, I said, Milord, that this part may be modified.
We'll have to restrict it to the.
No, I said, Milord, the question
regarding
of
back wages.
Yes, black wages I'm not entitled today.
Then
if he not entitled,
so the stigma will go.
The stigma will go, and I will reinstate it.
Your reinstatement you have joined somewhere else. How can
No,
we?
Milord, today, Milord, that is what Milord, even then,
Not of advantage of-
it is no, Milord, it is a question of discussion. Why should I work?
The relief has become infectious.
Milord, relief, Milord, I said, Milord, that the order, if the order goes, Milord, it has some ramification.
What?
That my prayer does not go, Milord. I said I kindly reinstate.
Will be the exact relief would be entitled.
Exact relief, Milord, reinstatement, without any back wages if I join somewhere. Reinstatement, my lord, because reinstatement, my lord, that I was
There
removed.
cannot be any
My
reason.
lord, reinstated in the place, my lord, because I was removed from the service. Today it is immaterial. I am
reinstated there
my lord,
notional.
why? Because Mr. Mujumdar, my learned friend, said that I had to make an undertaking in case of an industrial dispute that I was not gainfully employed anywhere. It only for the purpose that I am not even if dismissal order set aside, disciplinary
But
proceedings
I have
set
to give
aside.
you the option. If you set aside, would you go back there?
Yes, my lord, tomorrow I will come with a written instruction.
You would go back to the school
Yes,
if you set it aside.
yes,
You can give a written instruction on that.
yes, written instruction নিতে হবে তাহলে আমি মামলা করব না.
If we allow the appeal ultimately,
Yes, yes,
if we dismiss the appeal,
Yes, yes,
affirm this,
yes, tomorrow in the morning.
rejoin there,
Yes,
here in
Here.
Salt Lake School.
yes.
If that be so, that part will also remain. Then they can also reopen the in due process of law. They can do it.
Yes, Miller, today that is what I was arguing on the point. Today, Miller, the incident took place in 2012. Miller,
That's a different proposition.
Miller,
They
today,
can
Miller,
put it otherwise.
today, Miller, based on the document, based on this document, Miller, I said it is a question of bias. The same authority is there. I will not get justice from the same cause of action. That is my point.
You file a written your instruction tomorrow that you will rejoin this if this appeal is dismissed.
Yes.
But that does not impose a fetter on us not to allow the appeal. I mean,
No.
this is only your instruction.
Yes.
We are not opening our minds, but just
Yes.
yes. No reply is necessary.
No.
You want to say something else on waiver? Constructive resolution.
I said, Miller, that regarding waiver, the waiver, and he said that section 11, explanation 5, I also I argued, and also said, Miller, this is constructive res judicata.
Or might and not.
Huh?
Might and not.
And yes, and Miller, he cannot, Miller, escape, Miller, from the clutches and the purview of the division bench, which ultimately
Clutches of the division bench.
No, order of the division bench cannot take a different view. Today, Miller, this coordinate bench, he is inviting the court, and none of the judgments cited by Mr. Mujumdar, Miller, is on the point of aberration of regulation 1993.
Hearing is concluded. Full stop. At this juncture, it may be noted that one of the components of argument of the petition of the appellants is that in view of the private respondent number 1 having joined service in a different school, the relief has been rendered infructuous as of today, learned counsel for the respondent number 1 seeks to file a written instruction to the effect that in the event the order of the learned single judge is sustained, the respondent number 1 shall rejoin service in the appellant number 1 school. Full stop. For such limited purpose, the matter shall be listed tomorrow. Another heading to be mentioned. We have concluded hearing just for this filing of
extremely grateful, Miller, for your lordship's patience here.
Why? Why extremely?
I'm always extreme.
Yes. Absolutely.
I'm extremist.
That is the only submission on fact which you have made.
Additional groundটা এটা একটু সাবধানে
আচ্ছা পাওয়া যাবে ম্যাক্সিমাম গ্রাউন্ডটা দিন আপনি দিয়েছেন বাড়িতে
ছেড়ে যাবে বিচ্ছিরি ভাবে রয়েছে
কাগজপত্রের একটু কঠিন অবস্থা
কঠিন অবস্থায় বাঁধা দড়ি ফড়ি সব দড়ি দিয়ে মারবে অর্ডার শিট আলাদা থাকবে হ্যাঁ সব ফাইলে
গ্রাউন্ডটা দাও
অর্ডার শিট গুলো আলাদা করে একটা পাঞ্চ থাকবে ক্রোনোলজিক্যালি
Number 30.
Yes.
Well, in item number 30, I am appearing on behalf of, first they have claimed that I was the erstwhile advocate, and we have not acted diligently, and because of that, there is a delay in filing the appeal. If you see section 5 application which they have filed in this appeal, some expression has been casted upon the erstwhile advocate, paragraph 3.
You are for the
erstwhile advocate in one of the writ petition, what they have claimed.
No,
There
who
are
is
two-
the appellant here? The appellants have to move the section 5 application first.
But they have the direction to serve upon me.
No, we'll come to you later, but first, for hearing of the section 5, your presence is necessary.
Yes, yes. So there are allegations against the.
Yes, you have to answer those also.
Yes, yes. That is why I'm ready with all those answers.
Definitely. None appears for the appellant. We are giving them a last chance. If the appellants do not appear on the next occasion, then we will dismiss it for default.
Gotcha.
Although the other part, none appears for the appellants at the time of call, comma, although the respondents as well as the erstwhile learned advocate for the appellants are represented through counsel. Represented. Full stop, next para. As a last chance to the appellants to move the condonation application, comma, the matter is adjourned till August 18, 2026. Full stop. In the event the appellants are not represented on the returnable date, comma, appropriate orders may be passed ex parte in the absence of the appellants.
Obliged, Lordship. 18th.
Please remind us, suppose they don't appear on the next occasion, then, and if you dismiss it for default, just remind us, we'll make a note that it is deemed that none of the allegations made in the application against you are admitted.
Lordship. And I can show you also from the document, this time for more than 30 years of practice, this is the first time I've allegations
Against you?
Against my junior and against me.
Anyway, we should not be biased.
No,
There may be allegations
no.
against you have to.
I can show you from their conduct, how they have suppressed. Grateful. Take it. Obliged.
For the Union of India.
Item 14, my lord, appear for the writ petitioner.
Yes, Mr. What is that?
My lord,
This is 14. Go for
kindly-
the respondent.
Union of India. Yes, sir.
Yes, one of the respondents.
Yes.
Union is the main respondent. Yes.
My lord, in this matter,
Your writ petition was disposed of, dismissed.
the original
WP
application. The original application.
Difficulty with the assigned matters is that every matter is different. And one is an appeal, one is a.
Yes, my lord.
Anyway, what is your challenge?
My lord, here, my lord, the issue is, my lord, kindly before reading the brief, my lord, kindly once listens to me. The writ petitioner, my lord, was an employee of Indian Council of Agricultural Research. Since December 1991, he did not report for his duties. And in 2003, he was handed an order, 23rd April 2003, he was handed with an order saying that since you have not joined your duties, you are deemed to have resigned from your post and you're terminated.
What was your designation?
I was working as a scientist, my lord. Now, this order of deemed resignation was passed at a time when an original application was pending before the Central Administrative Tribunal. I'm sorry, my lord, where a challenge was laid against a decision to treat a period of 3 years as dies non. That challenge was subsisting. At that time, they issued this order of deemed resignation.
That has since been decided that way.
Yes, decided. That original application was ultimately dismissed. Seeing that you did not work, it was treated as dies none, so nothing can be done. I preferred a WPCT. In the WPCT, in 2016, I preferred a WPCT. In that WPCT, there certain observations were made while upholding the tribunal's order. The coordinate bench, my lord, made certain observations that the petitioner has in fact abandoned his service and deemed resignation order was proper. Against that, I preferred a review application. In the review application, these observations were expunged because the subject matter of deemed resignation was not a subject matter of challenge before the Honorable Division Bench. Then I made a representation for pensionary benefits corresponding to my qualifying service, which was rejected, saying, since you have been deemed to have resigned, you have forfeited your past service, therefore you're not entitled to pensionary benefits. That order, along with the 2003 order of deemed resignation, had been challenged before the Central Administrative Tribunal in the present round of litigation. Tribunal has said that the respondent authorities have rightly invoked powers under Rule 12 of the CCS pension rules, whereby unauthorized leave for more than 5 years is deemed resignation power can be invoked, and you have been rightly dismissed. Challenging that, this writ petition has been filed.
Continue after the recess.
Yes, thank you. Much obliged.
Yes.
Some embarrassment.
No, no.
Should we recall Friday, Your Lordship heard to order 41 for admission was admitted. Just in a short point, Mr. Thakkar said that I will come back. Unfortunately, those matters have gone down at 172 and 173.
No. That's because we take up different matters on different days. Today is designated for the specially assigned matters because people under every head comes and says every week that our matters are not being touched. So we shuffle those matters, and that is not permanent. Someday we would like to surprise our council, so we'll put it. The applications and order 41s we generally put first when they accumulate. I mean, then they're just keep a watch. Order 41 matters, when it is taken up, we'll reach all the order 41.
But it has even come under part-heard matter.
Part-heard করেছিলাম আমরা. It was made part-heard. না কিসের part-heard? Order 41 part. Yes, it was part-heard.
Appeal was
Your
heard in
Lordship
part,
just recorded appeals have been heard in part.
not multiple.
Yes. What does it mean?
Partly heard. But then, my lord, we will be.
So to be mentioned কাল দিয়ে দেবেন ওটা. I will direct it to appear before, even without that it. No, এই লিস্টে থাকলে তো ওটা পারবো না. Tomorrow it will appear to be mentioned.
Because the matter was.
You are going to mention this in the morning when you struck this.
There, but I could not get it.
It will appears to be mentioned. We'll pass the direction. It will appear before the regular bench. Regular bench also. Sorry, this is the regular bench. The irregular bench has several matters now, so we'll put that on a day and we'll take up those matters.
But it is better.
Including your
Lordship
matter.
takes it up on the regular bench.
No. Part-heard we cannot. We can cancel the part-heard in a different bench. Yes.
For time for the Indian Council Agriculture Research.
Right. Yes, Mr. Chakravarti, please continue.
My lord, may I hand over a fresh copy of the list of dates?
We have it. We
No,
have one.
certain dates are missing.
Oh, अच्छा, very good.
देखिए बाबू क्या लिखा
So we'll discard the previous one.
Yes.
Good.
It kindly comes to serial number 8 of the list of dates. And if I start from the beginning, my lord, the petitioner's father, when he's one of the petitioners over here in this WPCT, it's the widow of the employee and his son. They are the petitioners in this WPCT.
Achha.
He's the father has passed away. The employee has passed away. The petitioner's father joined the service of Indian Council for Agriculture Research as Scientist 1 in the year 1976. Thereafter, from 1981 to 1982, he had been granted a study leave. Thereafter, an extension was granted to him of another year. Now, again, from 1st January 1985 to 31st January 1985, an application was made by the petitioner's father seeking further extraordinary leave, which was refused. Ultimately, 1986, the petitioner father was allowed to join. Serial number 6. Then again, my lord, kindly comes to serial number 8 from 21/11/1987 to 15/11/1990. This period, he did not join his duties. This period was treated as dies none, and the petitioner's father was transferred to Cecil Research Center, Sambalpur. Challenging this decision of dies none, he preferred OA number 1197 of 1996. During pendency of this OA, order dated 23rd April 2003 was issued, whereby it was said that you have been deemed to have resigned from your post because you did not come back from 91 till date. You did not join your duty, hence you are disqualified. Ultimately, my lord, series of litigation ensued. There were original applications, review applications. Ultimately, my lord, what happened was on 13/11/2017, kindly comes to serial number 17 of the list of dates. Here, my lord, an original application was preferred by the petitioner's father seeking pensionary benefits. It was disposed of, saying that this will be considered by the respondent authorities. Respondent authorities gave a reasoned order on 18th of January 2018 saying that you are not entitled to pensionary benefits because as per Rule 26, since you have deemed to have been resigned, your past service is forfeited. You are not entitled to pension. That was challenged in the OA application. The OA application said, in the original application, it was said, the tribunal held that this order is proper, you are not entitled to pensionary benefits. That has been challenged over here. My lord, kindly comes to page 75 of volume 1 of W.
1 minute.
Yes.
Now, so your challenge is only to the 18 January 2018
18 January and 23rd April 2003, where I was deemed to have been resigned. My lord, kindly comes to page 75 of the volume 1. Firstly, my lord, kindly see, may I place the office order, my lord? On carefully examining the service records of Dr. D.P. Das, scientist of this institute, from 28 September 1975 to 28 December 1991, the competent authority is pleased to decide that Dr. D.P. Das deemed to have been resigned from council service with effect from 29 December 1991. The date from which he had been absenting himself continuously and did not report for duties thereafter. My lord, kindly notes the year during which this order was issued, 23rd April 2003. Now, my lord, this ICAR, the service regulations of the employees working under ICAR, they are governed by CCS rules mutatis mutandis. As per their own bylaws, my lord, these CCS service rules are applicable in their case. Now, my lord, this provision of deemed resignation appeared in the statute book for the first time in 2012.
in 2003, the provision of deemed resignation was absent. It was not there. My lord, to substantiate this, if my lord may see this.
Only.
2012. It's rule 12 type. Kindly sees rule 12 once of the rule book. Man, I have a Xerox copy of that page itself. Can
Give
may I?
Xerox copies. It will be easier to handle us.
Yes. Ditch. Kindly sees the
Yes.
footnote, my lord.
Yes.
Substituted by GSR 261E dated 29th March 2012. Old rule runs as under. My lord will find that under the old rule, there is no provision for deemed resignation, which is expressly there in rule 12 sub rule 2.
So 2 was not there.
It was not there, and that too, my lord, under rule 12 sub rule 2, my lord, it is guided by a proviso, provided that a reasonable opportunity to explain the reasons must be given. So even though if it is accepted that rule 12 was could have been invoked, a reasonable opportunity should have been given. It was not given in this case. Now, my lord, as regards also, my lord, kindly sees who has issued the order of deemed resignation. Kindly sees the director has issued the order. We take to the. I have handed over an appendix, my lord, delegation under CCA rules. This is taken from the website of ICAR. And over here, kindly comes to page 265, my lord. Bottom right, sorry, my lord. 265, page number. For all categories of scientists, my lord, the disciplinary and appointing authority is the president of ICAR, not the director. Not the director. Now, although now they have written in the order of deemed resignation, they have said that upon consideration by the competent authority, any anticipation that they may say that since it was decided by the competent authority, this is merely a signatory. The director is merely a signatory in respect of this order. So this might not be an impediment as regards jurisdiction. To that effect,